Chairperson, Commissioners, the main purpose of Reverend Chikane being here today, Chairperson, is for cross-examination in respect of the evidence he gave on the 19th of May 2026. However, Chairperson, before Mr. Chikane is subject to cross-examination, I would like to lead him on evidence that has become necessary as a result of certain developments. If I could just indicate what those developments are.
Yes.
After Reverend Chikane gave evidence, we had a statement from Masuka in which she challenged part of the evidence given by Reverend Chikane. Reverend Chikane would like to respond to those matters, and in order not to have a situation where there is cross-examination on the evidence led up to now in respect of Mr. Chikane, we would like to lead him on what Masuka has said about him, and he can then be cross-examined on everything.
Yes.
We submit, Chair, that is a fair process, because otherwise the first time that Reverend Chikane's affidavit would be placed on record, or averments would be placed on record, is during cross-examination.
Yes.
Now, may I then, Chairperson,
You may
lead
proceed.
Yes, thank you, Chairperson. Chairperson, may the may he be sworn in?
Yes.
Chairperson.
Reverend Chikane, you are reminded that you are still under your former oath.
Yeah. Yes.
Thank you, Chairperson. Reverend, you've heard my request to the commissioners for wanting to lead you in respect of Masuka's allegations against you.
Yes.
Okay. Now, before I deal with your response, Reverend, can I ask you, have you made a statement setting out your response to Masuka's allegations?
Yes, I have.
Can I ask you, please, you have a file in front of you, and if you turn to page 345 of the file, you will see a statement there. Do you recognize that statement?
Yes, I do.
Is that your affidavit in response
That's
to
it.
what Masuka has said?
That's
Can
it.
I ask you to please turn to page 350. At the top, is that your signature?
Yes, it is.
Do you confirm?
Reverend, if you can speak up a bit.
Oh, yeah. Okay. Yeah, it is my signature.
Yes. Reverend, do you confirm the correctness of what's contained in that affidavit?
Correct.
Yes. Now, Reverend, before I ask you to deal with the affidavit, may I ask you to respond to the following background to your affidavit? You gave evidence, after you gave evidence, Masuka filed an affidavit challenging some of the averments you made, both in your evidence and in your previous statement.
Yep.
You've seen Masuka's affidavit,
I've seen it.
and her affidavit appears at page 338 to 344. Is
Yes.
that correct? Yes. Now, You wish to respond to what Ms. Suka has said in her affidavit, and that's what you do in the affidavit you are now submitting.
Yes.
Now, in her affidavit at paragraph 31, which appears at page 343, if you could turn to that, you'll see that she says
Yes.
you confirm that.
Yeah, I
And
confirm
then
that.
at paragraph 31, she says that she asked you to take a public stance on this matter, and you, though, refused to do so. That's the allegation.
Yes, that's it. Yeah.
We'll come to your
We'll
response
come
to
that.
that.
Yeah. Yeah.
And then at paragraph 32, she says she wanted you to take a public stance and call out for the truth in respect to Flock and the others. And that process would have a powerful and symbolic act of reconciliation and healing. That's what she says.
That's it.
Then she goes on to say that she asked you to oppose the pardon applications unless Flock and the others made full disclosure.
Yeah.
Speak up, Reverend.
Yes, I will.
And then at paragraph 36 is her concern about how you dealt with her request having regard to the evidence that you have given. And she says at paragraph 36 at page 344, Reverend Chikane has asserted before this commission that his principal concern has been the pursuit of truth. I consider it appropriate to place before the Commission my account of our 2012 meeting, as it is relevant to his claim that Flock and van der Merwe had come out of the woodwork, took off their masks, and moved from their strategic lies. She's quoting from your affidavit in regard to those matters. In fact, she says, as late as 2012, they were still engaged in a cover-up of the truth. And then she continues in the last paragraph, paragraph 37 of her affidavit. Reverend Chikane's refusal to take a stand in pursuit of important truth for South Africans undermines his claim that his overarching concern was truth-seeking. That's her allegation against you.
Yes, I've seen that.
Yes.
I hope we'll be able to go back to that paragraph where 35.
Yes.
Yeah, where she says I was bitterly disappointed
Yes.
with his refusal to stand with the families and victims of apartheid crimes
Yes.
who were waiting for answers.
Yes.
Now, I would like to make a comment about that,
Yes,
if
yes, please
it's
go
the right time to.
Yes.
Yeah, I must say that I was disturbed about the statement
Yes.
because it's how many years afterwards that she's bitterly disappointed.
14
The
years.
point is, I have choices to make. And as a lawyer, she can't be bitterly disappointed about my choices. And at that particular moment, remember, I'm going through a real life experience. This is not just a show. It's a life experience. I've gone through these experiences where we had these battles about getting to court, people taking different positions. I ended up in court. I've spoken about that, to go and see the plea bargain arrangement. There were lots of pain. Then we go to the reports after, and then the media says, my statement to the minister and to the city press are contradictory. So now I must deal with, every time I go and deal with these matters, there's controversy I must deal with, it's pain. I'm the person who went through the pain. And I'm the victim, actually. And I become the center of all the debates. Even when you read the files and the statements, it's all about my case. And so when she comes at that point, and then we had gone through the Ginwala Commission as well, and lots of attacks on me. I go there as a victim, and I become the target. Now they want me to go through another process again. Yes. And my feeling was, no, I've had enough. I don't want to. That's why I didn't want to come here. Because I knew when I come here again, I become the subject of debate. And nobody worries about the pain I went through. Nobody. Nobody has talked about how I lost consciousness that evening in Wisconsin, and only opened my eyes at 2 o'clock in the morning and found a bishop of the Anglican Church, Archbishop Desmond Tutu, called a bishop in Wisconsin to go to my prayer, and I said it, I think, before. And they did the last prayers for me. And I opened my eyes. Nobody talks about that. Everybody's debating about their interest around my pain. I think that's the problem. So I don't understand. The meeting didn't end well. Yes. Because she was very angry. It looks like they built their case around me coming to do whatever I needed to do. And at that point, she refers only to government here. She refers to 34. When I asked him why he was unwilling to assist, he said that he had been poorly treated since he left government. That's not the main issue. The fact that I left government treated badly, it's unrelated to this matter. The real issue is my pain is being used to try to achieve other objectives without considering the pain I went through. And I just wanted to put it on record because my wife is here. When they told her at about 6 o'clock that, she can go home, she thought I was dead because I lost consciousness until 2 o'clock in the morning. So what I don't understand here, it's a lawyer who's dealing with a matter and gets so bitter about me because I made choices to say I don't want to go through this pain again. But I thought I must put it on record because I thought it was a very strange statement. But indeed, I've been in the struggle with comrades, Suka, if I have to call him a comrade. We have been together. But the day we met about this matter, that was it.
Yes.
Thank you, sir.
Reverend, may I, in regard to the issues that Masuka raises at paragraph 36 and 37, about, she takes offense at the fact that you commend Flock and Van der Merwe for coming out of the woodwork. May I ask, just for context, to look at how you put that matter in your first affidavit. Now, your first affidavit, Reverend, appears at pages 1 to, I think it's 24 of the file. If I could ask you, 1 to 25 of your file, can you please look at that? I want to refer you particularly to page 1 to 25, Chairperson, and I'm going to refer Reverend Chikane to page 17.
Of the five. Yeah.
Yes. That's
Yeah,
your first
that's
statement, Chairperson, Reverend Chikane.
Yeah.
Reverend, in paragraph 47, and we don't need to go through everything because the context is there. If I could just summarize this. In paragraph 47, you point out that after preparations had been made to arrest the 3 foot soldiers, namely Smith, Otto, and van Staden, in relation to the poisoning case, Mr. Flock and Mr. Van der Merwe entered the fray and started a line of communication with you. I'm just summarizing what's contained in paragraph 47. Is that correct?
Yeah, that's correct.
Yes. And then in paragraph 48, you say your position was simple. You say, my position was simple and deeply personal.
That's that, yeah.
Just disclose to me the story. Then use the channel the President announced by presenting the disclosure to the NPA, which would be expected to facilitate a plea bargaining arrangement to close the matter.
Yeah.
That was your position as you put it there.
Yeah.
And then at paragraph 50, you point out that there were several concerns that had been expressed by Mr. Van der Merwe and Mr. Flock and so on. Mm-hmm. And among those concerns was that if one person discloses, then that person would implicate others, and the implication would go on right to the top. In other words, to the persons who were ultimately responsible, namely the State Security Council, which was headed by President P.W. Botha at that time. And their stance was they couldn't take that leap. That was what was holding many of the perpetrators back. That's what you say in paragraph 50.
Yeah, that's correct. Actually, our strategy was to do exactly that.
Yes.
Get one person to admit and has to implicate others until we get to the ultimate. That was the strategy. But they had a difficulty that they would want to tell you what they need to tell you, but beyond that, they can't tell you about other people. Like P.W. Botha, all the statements I read, all of them end up with the language higher authority.
Yes.
That's if you read all the statements, files, they would say higher authority, and the only way for me to make that conclusion in a plea bargaining is that the higher authority was P.W. Botha.
Yes.
He took the responsibility, the decision to get the army externally to deal with those who resist apartheid and the police to deal with the internal was made in that Security Council meeting.
Yes.
Yeah.
Now, Reverend, though, what you do in paragraph 51 is you point out, to some extent at least, that Mr. Flock and Mr. Van der Merwe were exceptions to the fact that they closed ranks, as it were, and remained within the lager.
Yeah.
Can I then ask you, Reverend, because it's your affidavit, to read into the record again what you say at paragraph 51 of your first affidavit?
In the result, as often happens, the sad reality is that it is usually the foot soldiers who are the first targets when information comes to light about specific gross violations of human rights. This was what initially also happened in this case. It was Smith, Otto, and Van Staden who were the first targets. But that as it may, however dastly my poisoning, I have to respect Flock and Father Merwe for not abandoning their foot soldiers like some of their colleagues did. At a critical moment when the 3 police officers were at risk, Flock and Father Merwe came out of the woodwork, took off their masks, and moved from their strategic lies to protect themselves and their foot soldiers, that's the strategic lies, to declaring solidarity with their foot soldiers. They admitted what they had denied all along and were prepared to be charged along with their underlings. It is for this reason that they started the negotiations with the NPA, failing which myself. This is in stark contrast with the command of the apartheid South African Defence Force, because they were in command. The National Security Council was mainly in the defense, who were directly and primarily responsible for the poisoning project.
Now, you'll recall in paragraph 36 that it is those words, or some of those words, like Flock and then coming out of the woodwork, that seem to offend Masuka. Now, you've now responded to what Masuka said at paragraphs 36 and 37 and in her affidavit as a whole. And that's contained in your affidavit, which is now part of the file starting from page 345 of that file. Is the last document in that file, Reverend?
Yeah.
Okay. Can I ask you, because in this affidavit you succinctly set out some of the concerns you've already raised this morning, and also answer in context what the allegations Masuka made to you. Can I ask you to read this affidavit into the record, and for facilitating identification or comparisons between the affidavit and what will be on the record, if you could read it paragraph by paragraph with the paragraph numbers first, Reverend.
Is it the 345?
345. That's your new affidavit.
Yeah.
Yes.
Okay. You start from paragraph 1.
Yes, please.
At the request of the Commission's evidence leaders, I gave evidence in this commission on the 19th May 2026, and prior thereto submitted an affidavit dated the 28th April 2026. I place on record
Just indicate the paragraph number.
yeah,
before
paragraph 2, I place on record that I pointed out to the evidence leaders that I was somewhat reluctant to give evidence or even make a statement on the matters that were canvassed in my evidence. I informed them that I would have to relieve the pain and trauma that recall some of those matters engendered in me. I'm staggering because I'm thinking of what I thought yesterday night when I went through all the statements that I could use the expression, I was a dead man walking when you read all of it. I was between death and life every moment. I'll go back to the statement. I was, however, persuaded that my evidence will assist the Commission to better understand some of the issues that this Commission is required to inquire into. Paragraph 3, I am informed that in relation to me, there are two developments that have taken place since I gave evidence. The first, there has been an application for me to be cross-examined, and that application has been granted. The second is Miss
Sorry, Reverend.
Paragraph 5.
Yeah, 5. I mustn't forget that. 5. Miss Yasmin Suka, who had also submitted an affidavit to this commission and gave evidence before I gave evidence, has now submitted a further affidavit dated 10 July 2026. In that affidavit, she, in essence, says the following. My claim in my earlier affidavit and when I gave evidence that in making inquiries about my poisoning, my principal concern was the pursuit of truth, is undermined by my refusal to be opposition of certain organizations to the grant of pardon to those who had been convicted and attempting to murder me by poisoning me. 6, as regards the first development, I accept, as I was told after I gave my evidence in chief and clarificatory questions had been answered, that I may be recalled for the purpose of cross-examination. The purpose of this affidavit is accordingly to deal with the second development I have referred to above, and in particular to respond to the inference that Ms. Suka draws from my unwillingness to become involved in the opposition to the applications for pardon made by the 5 persons who had been convicted and attempting to murder me. 8, I begin by pointing out that it is so that Ms. Suka and Mr. Vani approached me to join them in an initiative they were involved in to oppose the pardons for which the convicted men had applied. In response, I told them that I was unwilling to participate in the initiative or process they were embarking in. 9, my principal reason for not participating in their initiative or process were the following. First, as I explained when I gave evidence before this commission, the attempt to murder me by poisoning me have regard to the totality of the circumstances has been highly painful and traumatic for me, and being asked to go through the details thereof, even if only briefly, revives that trauma and pain. Second, as I indicated in my earlier affidavit, in my evidence, I had to relive that trauma during the several and sustained attempts I was required to make to gather information relating to my poisoning. 12, third, I again relived the trauma and agony during the plea and sentence procedure through which the convictions of the 5 pardon seekers were obtained. forth in paragraph 13. At the time I was approached by Ms. Suka and Mr. Vane, which was some 5 years after the then accused persons were sentenced. My state of mind was that I did not want to have to relive the trauma yet again. I conveyed these matters to Ms. Suka as Mr. Vani. 15. I perhaps need to add, with each formal recall of that traumatic experience, the pain and trauma increases. 16. In the circumstances, I am deeply, deeply saddened that Ms. Suka has chosen to seek publicity to challenge my integrity. 17. In this connection, I accept that she is bitterly disappointed, as she revealingly puts it. I am constrained to record that she was angry during the meeting, which on account of my refusal to participate in their process, to which she appeared wedded, did not conclude on friendly terms. With respect, however, that is not a legitimate basis to seek to malign me in the terms she does. 18. I also point out that at the time the plea and sentence agreement was entered, which I emphasize was an agreement between the accused and the state, I was of the view that I had got all the information that the convicted persons were willing to impart. Accordingly, at the time I was approached by Ms. Suka and Mr. Vani, I did not think that they would impart more information to me if I participated in Ms. Suka and Mr. Vani's process, or made my non-participation therein conditional on further disclosure by the convicted men. At 19, those were my views. The fact that Ms. Suka strongly held views that were different from mine is, with respect, not a legitimate basis to challenge the validity of those views or my commitment to seeking the truth. In this connection, 20, I also record that my assertion that Mr. Flock and Mr. van der Merwe had confessed to their involvement by coming out of the woodwork. And it is, just to explain, it's about my case, it's not about other cases. It's what I was dealing with that affected me. They did come out of the woodwork, taking off their masks because I engaged them, and moving from their strategic lies cannot legitimately be gainsaid. To the best of my knowledge, Mr. Flock was the only minister of a security-related portfolio, and Mr. van der Merwe was the only head of a security force entity who publicly took accountability for their dastardly deeds against me. 21, that they did not confess to all the harm and pain that they caused to many, many others, or did not implicate others, ought not to diminish how far they had moved from the lager in relation to my case. 22, in the premises, I dispute the correctness and sustainability of the attack on my integrity that Ms. Suka has regrettably made in her affidavit of the 10th of July. I respectively point out the following in this connection. That's 23. 24, first, my not agreeing to participate in their initiative is not at all inconsistent with what I said in my earlier affidavit or my evidence, namely that I did not want the perpetrators to be prosecuted for the sake of prosecution. I wanted to know who was involved in my poisoning. I wanted a public acknowledgement of what they had done. And I did say in the past that I was suspicious that people could be charged to be released. If you don't have evidence, enough evidence, you can be charged, knowing that they will be released in any way. I didn't want that outcome. I wanted to get as much as possible from them. In 25, in the course of securing these ends, I had told them that I forgive them. 26, in making my decision whether or not to participate in Ms. Suka and Mr. Vani's process, I could not ignore the foregoing matters because it had to do with the matters that I was dealing with. Ms. Suka's strong disagreement with my views and my decision, it's not a proper basis to dismiss the views of a victim of the atrocities of the past. that ends it.
Yes. Thank you, Reverend. That's the affidavit. I just want to ask you one further question because the affidavit deals with all the allegations made by Ms. Suka that you are concerned by. In regard to the pardons process that they were embarking on, it appears that there are, if you look at the file, from pages 200 to page 337, and you'll look at it, if you look at the index in front of that file, you'll see that it's from item 24 to item 29.
That's page.
Those are pages 200 to 337.
Yeah.
And on the index, they appear as items 24 to 29.
Yeah.
There are various...
Mr. Soni, we are not on the same page
I'm
with you.
sorry, Chairperson. Chairperson, you will see that in front of the file, there is an index which is headed Index Collater Group Bundle to Cross-Examine Frank Chikani.
Yes,
So it is that bundle that I'm referring to,
yes.
and the items are on the left-hand side on page 3 and 4 of that bundle. Chairperson.
Yes.
And then the page numbers are on the right-hand side. Now, Reverend, in these are the documents that are contained in this file. They relate to the pardons process. When did you first see them, these documents?
Yeah, this question I think was asked before. Did I go through the documents? I don't remember. I read these ones after midnight in details.
This is midnight last night.
Last night, yeah, to know what is there. And it's a very interesting reading. I mean, it's Flock and Van der Merwe and others now not making a submission in court, but for the pardon. And I got more information about what they were doing, which is very interesting. But I don't remember reading all this. It was new to me. I've also picked up, I hope their name is right, that before Smith executed the command, there was somebody, I think, called Stradom or something,
Stradom, yes.
who actually was not eager to carry out this command to kill a number of people. And I thought, I'm interested in this man. This is the man I've never talked to help me to understand what his thinking was at that point, because he had my name there and I must be killed, and he didn't execute. I don't think he stayed long. They either promoted him but it was a very interesting reading for me. Yeah, but I don't remember. I wouldn't have gone through this even if they had it, because I didn't have an interest in going through this process, because it's difficult for other people to understand, but I was walking around every moment close to death, every moment during that time. I was not in exile, I was here. And Hotza House get bombed. Now I know they say it was like a headquarters of the ANC and the SACP in the documents. That's why they had to get rid of me. Yeah. But no, I don't remember going through them. It was interesting reading.
Yes.
Sorry, Reverend, I don't know. Are you putting a date on when you saw these documents for the first time? I may have missed that.
No, I'm saying I read them after midnight, which means
Is it when you saw them for the first time?
Yeah, I think so, because
Okay.
if I picked up new things I didn't know, then it means I didn't go through them, even if they might have come with them. You know, I have no recollection of that.
Yes, thank you.
But what interests me is that it has information that's useful to know what was happening on the other side. And I could say, commissioners, that I felt this morning as I went through it and these files and the witness, that I was a subject of discussion everywhere, within government, at places where I wasn't, and including the security establishment planning how to kill me. So it's interesting, but it tells you I'm lucky to be alive, to be here.
Thank you.
Reverend, my final question to you is this. In her affidavit, Ms. Suka doesn't say what happened to these applications. In other words, what the outcome of the applications by these 5 people were.
Your voice is dropping, Mr.
I'm
Sodi.
so
Yeah.
sorry, Commissioner. I say in her affidavit, Ms. Suka doesn't say what the outcome of the applications of these 5 people were. Are you aware of what the outcome was?
No, actually, I mean, I was long out of government when she met me. 2012, I left government 2009. And so I wasn't following the process at all. And when one read a report about parliamentary debate with President Zuma, talking about some of those pardons are on her desk by 2015, it tells me that it had not been processed, or some might have been processed. I don't know. I don't know how it ended, because I really had no interest in following it. It's just too painful for me to get back to it.
Chairperson, that is the evidence we intend to lead. And
Yes.
of course, Reverend Chikani would now be open to cross-examination.
Yes, thank you.
And if you could switch off your microphone, Mr. Sodi.
Mr. Vani?
Thank you, Chairperson. Chairperson, before we commence, the two applications that have been granted for cross-examination today, that's ours and also that of the Minister of Justice. In terms of seniority, we assume that the Minister would go first.
Yes.
Before she does, we have placed certain concerns on the record in a letter we addressed to the Secretary last night. I can place it on the record if the Chairperson permits. We're not suggesting that this must be dealt with and resolved now, but I do want to flag that for the Commission's attention.
Yes. Ms. Moroka?
Can I respond to both, Chair?
Yes.
Our understanding that we're going to come second in cross-examining. But the first issue about the letter that was sent yesterday, I received it at 1800 hours. With your permission, Chair, I would want to respond to that letter quite substantively and not just put it in just for the purposes of the record. So I'm not sure whether Mr. Vani wants to deal with his letter so that I can respond to it.
Yes.
Because I do want an indication from the Chair on the way forward on this issue.
Yes. You'd want to respond substantively.
Yes, Chair.
Yes.
Not by letter or anything like that, but I can address what the letter says. And that's what I mean when I say substantive.
Yes.
Yes.
Are you in a position to do that now?
I am, Chair.
Yes, you
I
may
didn't
proceed
sleep,
to do so.
unfortunately, because
Chairperson, before she proceeds, I imagine I should lay out our concerns first.
Yes, yes, you may proceed, Mr. Vani.
Thank you, Chairperson. And I'll rely essentially on the letter that we addressed to the Commission yesterday evening. I don't know if the Commissioners have copies of that letter.
Yes.
So essentially it came to our attention during the course of late yesterday afternoon that Advocate Morocco, on behalf of the Minister, had in fact put questions to Reverend Chikani by way of clarification on the 19th of May earlier this year when he gave his evidence in chief. And we did check the transcript, and that is the case at pages 85 to 89 of that transcript. So we wish to seek clarity as to whether parties are permitted to ask both clarification questions and then come back a second time to cross-examine, because we were under the impression that parties had to make an election, either question by way of clarification or cross-examine. As far as we were aware, it wasn't permissible to do both, which we assumed the Commission would view as improper. Now, the Minister's application to cross-examine didn't disclose this fact that clarification questions had already been posed. And so we raised the question, if it had been disclosed, then the application may have been viewed in a somewhat different light. We also noticed that at the time of the Reverend's evidence in chief, the Minister's team did not apply to cross-examine. That application only came on the 27th of July, and that was some 12 days after the family's application on 15 July. And that does raise a concern that the application to cross-examine has not been prompted by the Reverend's evidence, but rather by the application by the families. We set out in some detail, and I don't want to take up too much time dealing with the application because it refers to the fact that the Reverend Chikani, some of his evidence relates to the Minister or implicates the Minister. And we point out that we don't see any evidence of the Reverend implicating the Minister of Justice or the Department of Justice. We also noted with concern that some of the clarification questions posed on the 19th of May overlap with issues that are listed in the Minister's application to cross-examine. And we set out the overlap in paragraph 10 of the letter, dealing with the Reverend's interactions with Advocate Ackerman and the Reverend's letter to Minister Mabandla. And there's no explanation in the application as to why the clarification already obtained by Advocate Morocco was inadequate, prompting the need for cross-examination. And then in the remaining issues, it's essentially a request to pose questions to the Reverend so that he can explain his evidence further. The application doesn't disclose any attempt to dispute or challenge the evidence or put up a competing version or to point out inconsistencies. It doesn't explain why his evidence in chief on those issues were inadequate or why the Minister requires further explanation. So it does seem to us that the Minister's intention is not to cross-examine the Reverend in the traditional manner, but rather to give him a further opportunity to elaborate on his evidence in chief. And we would suggest that this is not proper for cross-examination, that's proper for clarification. So those are the issues that we sought clarity on, Chairperson.
Yes. Thank you, Mr. Vani. Ms. Morocco?
Thank you, Chair, for the opportunity. If I may start off by saying we lodged the application on the 27th of July 2026, and the application was granted on the 29th of July 2026. Today is the 13th of August, and this objection only comes on the 12th of August, when the Chair has already made a ruling in this regard. We're told that once you ask questions of clarification, you cannot cross-examine. We wish to place it on record, Chair, that this is a truth-seeking exercise, and that there is nothing preventing a party who raised issues of clarification from cross-examining. We do not know why this contention is being made. There is no reference to the rulings or the regulations of the Commission to support this assertion. The Chair has never made such a ruling that once you ask questions of clarification, you cannot cross-examine. I will come back, Chair, to the purposes of cross-examination, but if I may point out that Mr. Vani himself agreed in the evidence of Mr. Nguka at page 53 on the 2nd of March 2026 of the transcript that when he was asked whether he had any questions for clarification, Mr. Vani answered, "I think it is probably best that we do not question all at the same time, both by way of clarification and cross-examination. We therefore submit that Mr. Vani knew that there's a distinction between the two, and one can do the two at different times or at the same time." In Mr. Lala's evidence, on the 10th of April 2026, when Advocate Smenya pointed out that cross-examination is not a right, the Chair clarified that it is not a right, but that we have a right to apply, and the Chair will then consider the application. If I then go to case law, Chair, and the purpose of cross-examination, where we are told that we are not cross-examining, may I make reference to what was stated in Platinum Mine Resources, Pty Ltd, versus the CCMA and others, in brackets JR 427/20, 2023, on the 1st of March 2023, where it was stated, after a witness has given his or her evidence in chief, the other party is given the opportunity to cross-examine the witness. The intended purpose of cross-examination is, inter alia, reveal the weaknesses in the evidence adduced, to challenge the truth or accuracy of the witness's version, to bring to light facts reinforcing the cross-examiner's case to elicit favorable facts. And if Chair, I can underline that, it's not written to, so you are not able to see what we are underlining, but if I may then be permitted to repeat, to bring to light facts reinforcing the cross-examiner's case to elicit favorable facts, to place a defense on record and put the version of the cross-examining party. In State versus Umotoso and others, CC 15/2018 in brackets 2025 on the 2nd of April 2025, the following was stated regarding the purpose of cross-examination. The object of cross-examination has been defined in these words. It should be borne in mind, as we quote, that the objects of cross-examination are three. The first positive and the other two negative. They are to obtain evidence favorable to your client, to weaken evidence that has been given against your client, and finally, if nothing of value which is favorable can be obtained, to weaken or destroy the value of evidence by attacking the credibility of the witness. If one were to go to Google for an explanation, some of us are quite young, Chair, and we use Google. It gives three
Why are you looking
purposes.
at me?
Three purposes. Because Mr. Vani yesterday didn't even know how to use a phone and have three parties on a phone, Chair. I had to teach him. Is that part of cross-examination does not of necessity mean destroying another one's version. It can also include, and it does include, supporting your own version of events. So therefore, the notion that we are here only to challenge Ndate Chikane about his evidence is not correct. And it is not correct that that is our intention, just to give Mr. Chikane or Muruti Chikane a second bite at the cherry, as it were. We are set, Chair, that we do not know where this understanding comes from Mr. Vani. Our understanding has never been that we can ask questions and then later apply. And that is the discretion that is left entirely to the Chair. In conclusion, if I may refer to the Chair's ruling in Nuka's application for cross-examination, where the Chair indicated in her ruling, I issued a ruling in this matter on the basis that it was made under Regulation 8 in brackets 3, read with Regulation 7.3, which reads as follows. Any witness appearing before the Commission may be any witness, whether implicated or not, may be cross-examined by a person only if the chairperson permits such cross-examination, should she, that is the chairperson, deem it necessary in the best interests of the functions of the Commission. I therefore direct that Nuka the only change that the Chair made to her ruling was to the date that Mr. Nuka was to be cross-examined. He was not to be cross-examined on the date that he was appearing, but on a later date to be determined. We would submit, Chair, that it is common cause that most of us asked the Reverend questions of clarification. Nowhere was there an indication from the Chair that therefore we cannot apply for cross-examination. It is your ruling, and we would submit, Chair, that your ruling stands. Thank you.
Yes. Mr. Vani, any response?
Chairperson, we hear what my learned friend says. And, you know, it may be that there is value in having two bites at the cherry, in asking questions for clarification and then coming back again for cross-examination, certainly from the side of the Kalata Group. If we were aware that was possible, we would be asking clarification questions with each and every witness and then making a determination as to whether we should still apply to cross-examine. But it's always been our impression that that was not the approach of this commission that one had to make an election. The quote in relation to what I said when we indicated an application that we would apply to cross-examine Advocate Nguka, I don't think is of any assistance, because we made it clear that it couldn't be done at the same time. Madam Chair, those are submissions. I do have other submissions in relation to the order of cross. Should we go ahead?
Yes, just there, Mr. Vani. I thought you would even now concede that the picture has changed now that Mr. Soni led further evidence today. This would then also give further credence why those who applied for cross-examination, who asked for clarificatory questions or elucidatory questions previously, may still then cross-examine. You follow what I'm saying?
Yes, Commissioner, I do follow, but we do need to point out that in the Minister's application, which came after the filing of Ms. Suka's affidavit, there was no mention of the issues raised by Ms. Suka in the application.
Yes.
Thank you. I think this would be an appropriate time to take a tea adjournment, and we'll reconvene at 11:30.
As the Commissioner please.
This is the ruling I made after having heard the submissions made by Advocate Vani and the response thereto by Advocate Muroka. An application for the cross-examination of Reverend Chikane by Ms. Muroka has been applied for and granted, and there is no application to set aside that ruling. The submissions made by Mr. Vani with regard to the cross-examination of Reverend Chikane by Ms. Muroka do not refer to any breach of our rules, and we can find none. In the result, the cross-examination is permitted to continue as granted. Mr. Vani, you may proceed.
As the chairperson pleases, Chairperson, we confirm that we did not apply to stop the cross-examination. Chairperson, I want to make submissions on the question of the order. We've already made the point that normally in this commission, seniority detects
Yes.
order.
No issues with it, Chair. My preference would have been that Mr. Vani goes first, but in your hands, Chair.
Yes. Ms. Muroka, you don't want to take the privilege you enjoy?
That privilege goes with age and it goes with all other sorts of things, Chair. At this moment,
Yes.
I defer. I don't take the privilege.
Would you prefer Mr. Vani to proceed?
I prefer Mr. Vani to
Mr.
proceed.
Vani, you may proceed.
Well, Chairperson, in that case, since the normal order is disturbed, I need to make submissions why we believe that
Yes.
Ms. Morocco should go first.
Yes, you may.
Chair, in order to cut through all of that, I have no issues with starting.
With proceeding?
No, I haven't.
Yes, you may proceed,
Thank
Ms.
you,
Muroka.
Reverend Chikane has just approached me to say that he would like to correct something that he said earlier this morning. May he be given leave to do that?
Yes.
It's a very small issue.
Yes. Reverend Chikane, you may proceed.
No, thank you very much. I thought even if it's small, but it must be fixed. I talked about losing consciousness at 6 o'clock. And it was the time when my wife left the hospital. But I lost consciousness at 2, so it was 12 hours from
Yes.
2 o'clock to 2 o'clock the morning, 2 o'clock afternoon to the morning of the second day. So just to correct that, otherwise all the other writings talk about 12 hours. Thank you.
Is that all,
That is
Mr.
all,
Sonny?
and we're most
Yes.
indebted to you, Chairperson.
Ms. Muroka, enjoy your privilege.
Thank you, Chair. I'm indebted to the Chair. Ntate Moruti, I'm going to be very short, and thank you for coming back. Somebody asked you if you're okay. I think it was Mr. Vani. You don't. I hope you are okay.
No.
Oh, sure.
I'm okay.
Okay.
I've been in the trenches for a long time.
I know.
Akasibi sharp, Alimo.
My apologies, Chair. We are township people, and language, what's it called, evolves. Ntate Moruti, you've got the bundle in front of you.
Yeah.
We're going to use the same bundle, Chair, as the Kalata Group bundle. We believe in non-cutting down of trees, so our view is to use the same paperwork. If I may, Ndade, I'm going to really concentrate on your dealings with Advocate Ackerman, Mr. Ackerman.
Yeah.
And I start off by quoting what you say. And you say that,
Where?
I'm looking for it, at page 21 of bundle 60.
Right at the beginning. In my statement, page 21. Yeah. Got it.
And you say there that you found Advocate Ackerman's approach to be a punitive one and not within the spirit of the post-TRC process and the President's call, including the muted prosecution principles relating to the unfinished business of the TRC. So my question to you, Muruti, is you refer to prosecution principles, but these are not the same as prosecution guidelines. You're talking about prosecution principles of seeking the truth. Would I be correct, or am I mistaken in my understanding?
Yeah, I can't be particular about, I called it guidelines, isn't it? Not principles, but indeed there were differences in terms of the two. So whichever is correct, I didn't go and check again. It's based on memory.
Thank you. But your issue was essentially the pursuit of truth.
Yeah.
Thank you. And if we refer to the speech by the President, the famous or infamous speech by President Mbeki, he did not talk about guidelines or principles in that speech. Do you recall, or you don't?
Yeah.
It was in 2003.
Yeah, I would have to be reminded.
What he essentially said was that he leaves the matter in the hands of the National Directorate of Public Prosecutions for it to pursue any cases, as is the normal practice. If the NDPP believes it deserves prosecution, it can be prosecuted.
Yeah.
At that, and I state, because it is part of the record, that Advocate Piccoli then set about trying to unpack what the President meant.
Yeah.
Because at that stage, the President did not talk about prosecution policies at all in his speech.
If I remember well, the speech was more about what do you do after the report of the Truth Commission. And we're all struggling about how you handle the post-TRC. In that process, there was no debate about whether or not you could prosecute people. The debate I was engaged in was more about how do you deal with people who have not come to the Truth Commission? How do you deal with that? And of course, if you have got evidence, if we had evidence about Flock and Otto and all that, they would have been just charged. You know, they didn't have to wait for anything because you had evidence. But if you didn't have it, then you have to deal with it differently. And that's how I dealt with the Flock and Van der Merwe matters. Wanted info because, sorry, I need info that we don't have. And that's, you need another process. And there was a debate about how you do it, whether it's guidelines, principles, policy. It was outside my scope.
But from your personal perspective, you became a sleuth.
You became?
A sleuth, S-L-E-U-T-H.
Yeah.
You became an investigator on your own.
Well, yeah, I started my investigation from day one. We started the investigation from day one. You remember we talked about, before I came, talked to comrades, suspected, because in the US they suspected it. I just landed in the hospital because I went past where my dear wife was studying. And I got hit there for the second time. At that point, in that hospital, they were trying to work out what it is. And once we got suspicion, we developed a suspicion, they then quarantined my area, the ward, put security around it, and we communicated back home. It might interest you that it was a African American military person, you know, who was in the war and simply said, I've seen this before, because they couldn't work out what it was. And that's when the suspicion began. I was moved, even residents and all that. When I returned, calling on
commissioners.
yeah, okay.
If we carry on, we're still on yourself and Mr. Ackerman.
Yeah, so by the time we came to government, that's when I had authority, although it was personal, but working from the position of a director general first, advisor and director general in the deputy president's office, and then in the president's office. I had more possibilities than when we were working from outside. And now I could write a letter to Flock, Surgeon General, you know, the previous, commanders, and I did a lot, including the clerk and various other people. They got my letters. But the advantage is that I was in government, and interestingly, they responded. I also asked the new ministers, like Minister of Police, who was new. I asked them because I wanted them to tell me what they know about it. And most of them said they know nothing, even those who knew. And later admitted they knew about it.
It's called leverage, is it not? You now have leverage.
It's leverage. Well, I think I must admit, because I can't argue somebody should have done what I did. Because of my profile, I couldn't be ignored. I'm sure if an ordinary person sent a letter to the former police commissioner, they would just ignore it. I even sent them to people who had retired to ask them. And it's interesting to go back to those letters, actually, the responses, the lying. And so by the time, the issue of by the way, I also must say that I was part of the development of the idea of a Truth and Reconciliation Commission before 1994. And indeed, it didn't come out to be what we wanted it to be.
Sorry, Reverend, you did mention that in your original statement,
Yes.
so we will not go into that.
We don't have to repeat that, yeah.
Thank you. So if I might just go to your oral evidence, again where you talk of Mr. Ackerman, you state, I think, and in brackets, Ackerman just wanted to do a prosecution, and it is his job to prosecute. And I've said so that my worry was that I was suspicious that his prosecution for the sake of prosecution and that they might go free because there might not be enough evidence to pin them down. And the Galata bundle then goes on to say at page 64, and they refer to your evidence again at page 64. It's a long paragraph. I will not read it. But essentially what they're trying to say is that what you said is, I think he just wanted to do a prosecution, and I repeat what I've just said now. Would I be correct to say the difference between what you understood Mr. Ackerman to want to do and what you wanted to do was that yours was a pursuit of truth and his was a pursuit of legality. Would I be correct in saying that?
Well, you could be correct, but let me put it from the way I understood it. Remember, this is an extraordinary integration of old order and new order. So there was lots of suspicion. You never knew who is going where. And I've said in my evidence that I was worried that people could be charged for the sake of getting them acquitted. If you don't have enough evidence, you could charge somebody and then go and lose the case. And I was more interested in getting more information from the people who I believed had information. And so I wasn't interested in charging people for the sake of charging them if there wasn't sufficient evidence to convict. And that if they are found not guilty, it means that's the end for me. I can't pursue the information, but I wanted to get the information. And I think circumstances forced Flock and Van der Merwe, first Flock, to come to me because they hit a rock at the NPA. They thought they would sort it out there, and they came to me, and I said to them, I am not interested in the issue of prosecution. I'm interested in information from you. And they gave me the information ultimately. They were in a bind. And they gave me the information. That's why later, Ackerman, when he got angry, because I didn't sign that piece of paper, he then threatened.
I'm going to stop you again because we're going to get there.
Yeah.
Sorry about that, Murud.
No, that's okay.
Would I be correct then to say that your relationship with him was predicated on mistrust? And let me explain why I say this, with reference to what you said in evidence.
Yeah.
You say, I could not dictate to them, to the NPA. The prosecutors, I could not dictate to Ackerman, but I was suspicious that he may do it as a part of their strategy to negate this. I did not trust them. At the point when Flock and Van der Merwe came to me, I collected more information from Flock and Van der Merwe because they wanted to get help. But the essence of what you're saying in this paragraph is that you actually did not trust Mr. Ackerman.
Yeah, no, I accept that. That there was lack of trust. It was all around. It wasn't just about Ackerman as an individual. I had no relationship with Ackerman. But I had to have my tools of suspicion to watch everything that happened around. So if you say, by the way, I didn't stop him prosecuting anybody. Throughout my evidence, you can see that he should do his work. But I want information. I don't want the process that will block me getting the information. And I wanted it recorded in court, that admission, which we achieved that, yeah.
And your mistrust is collectively underpinned by the history of the country, the history of apartheid, and the history of the accommodation that had to happen.
Yeah, as I'm saying, even when I went to court, I've said it before, even when I went to court for this plea bargaining, I mean, it was a funny court, you know. The accused were white, the prosecutor is white, the judge is white. They did it in Afrikaans. Then there was no interpreter. I mean, it was a strange court that didn't recognize my presence at all. So But I didn't stop looking for the information I wanted. And I was just happy it's recorded. I don't like the plea bargain arrangement and the language, terrible language. But I got what I needed.
So you must be pleased that transformation has indeed happened. Muruti, you see two, as it were, judges in front of you today.
Yeah, and that they can speak in a language I understand and get an interpreter if I need to. No, I think we should accept that the area of the judiciary took longer in terms of transformation. And even when they acted, they were normal. You know, it's how many years? 2007, since 94. They acted like, it's a new South Africa, but they acted like normal. They didn't actually realize I'm sitting there. And when they gave me the document, it was in Afrikaans as well. So I struggled to understand. I can struggle to understand Afrikaans because they also gave me an Afrikaans Bible when I demanded for a Bible in detention. And ultimately, when the judge made a ruling I must get a Bible, they gave me an Afrikaans one. And I read it 3.5 times, from Genesis to Revelation, because that was the only thing I had to read in that long detention.
Your microphone is off.
I
Yes.
just switched it off by mistake. Moving on to the meeting with Advocate Ackerman, Mr. Ackerman, when he presented the document that you refused to sign. You recall that?
Yeah.
You did say in your testimony, or he testified that he doesn't recall exactly what transpired, but his recollection is set out in pages 153 of the bundle
300
and 153 at line
Okay.
12, or
Yeah.
beginning at line 12. So that we move faster, can I read it? I can remember also that I explained to him that if he does not give me the correct version and that there are some other, he can be treated as a recalcitrant witness and is really not happy with it. I'm not happy with his attitude and declared him hostile. I said that it is in the act. And of course I think that upset him because somewhere I read he says I was very hostile towards him. But I think it is because I explained all the legal sections of the Criminal Procedure Act to him. In any event, in his own letter, Maga, there is a full record of what happened at that meeting. I then proceeded with the prosecution, and that is all that I can say about the matter. If I may just continue, Maga on his version says, I did not recall threats being made in that conversation or in that meeting. Anton's personality is a person who is aggressive. And how do I put it? He can be aggressive in his approach and posture. He is not necessarily measured, but on that day we were offered tea and cookies. It was a relaxed conversational engagement in which did not take very long, when Reverend Chikane was non-committal about signing the letter.
Yeah.
And Maga is page 193 of the bundle.
Yeah, I was going to ask that, yeah. No, I read all that, actually.
And you do not agree with it?
No, actually, I'm very surprised about, is it Maga? What's his name?
Maga,
Yeah.
M-H-A-G-A.
Yeah, I was a bit surprised. It surprised me because in my affidavit, I do say Ackerman was with another person and that person should be a witness of what happened there. I really trusted he would actually know that, but he describes Ackerman. That description is very interesting and then ends up with cookies and tea. I mean, in my office, I give everybody cookies and tea I don't say you are hostile or you're not hostile or you're going to be hostile. I offer them that. So it shouldn't be a surprise. But I expected him to remember all that. He remembers the note I was supposed to sign, and I said no. It's only at that note, no, that the hostility came up with Ackerman and threatened me. I can't see how Mark would forget that Ackerman even quoted the section under which he would force me to surrender the information I got from Flock. And I said to him, well, try it. If you want to, the apartheid system failed to do that to me. You can't forget such interaction.
And
But the character that's described of Ackerman, he might have been used to Ackerman behaving like that. You can see the way he describes that character. And he may not have thought there's anything wrong because he's used to him behaving like that. But I can't accept a person who threatens me. Once you threaten me, that's the end. And I said, go ahead and do it.
And you say that at page 54 of the bundle,
Yeah.
in your transcript at line 80. You don't need to go there. It was
Yeah.
just to make the reference. But you,
It
Oh,
might
sorry.
be that that's how he operates. It might be that's how he does his work. But you can't do that with me. Once you do that, I remember the apartheid system and how I've been treated. So I don't want to be treated like that. And he left. So that's why I suspect we didn't even go through the plea bargaining document, which was written in a bad language, which I would never accept it.
but you did not see that plea bargain agreement. At that meeting, it was not offered to you. It was just a document.
No, I can't remember. When Piccoli intervened, because after that interaction, I actually initiated the interaction with Piccoli to say your man behaved in this way here. And Piccoli almost took over from there and only shared the issues about plea bargaining, the sentencing, that was there, but not the document itself.
We're going
Because
to
if
get-
I read that document, I would have said...
Can I interrupt,
Yeah.
Dr. Chikan, because we're going to get to the timeline
Yeah.
to show whether at that meeting the plea bargain was in play. Because according to what we have read, it doesn't seem like the plea
It was
bargain
in
was
place.
in play at that time, according to Mr. Piccoli's evidence.
Yeah, I would accept that because I wasn't handling, that's their business. But I expected that before we went to court, they would have, there's a reference in the plea bargaining that said they consulted me. And they talked to me about many things, but the actual text is what I contest.
Because Mr. Maga then says at page 188 of the bundle from line 19 that there was a letter that was prepared by Advocate Ackerman, which was a confirmation that he had consulted, which required his signature. And that signature would have been proof that you had been consulted. And that is what you take issue with.
Yeah, I take issue because the approach in that meeting was that I'm interfering with their process. They are doing their job and I'm doing my other job with Flock and others. There was a feeling that disturbs their process and wanted me to sign this document that they wanted me to confirm that they talked to me. I didn't sign that document for two reasons. One reason is that it's almost like here's a document, sign it. Now, I don't do that. You know, I study things, test. I don't just sign a document. Secondly, I felt at that time, when I read it this morning, I thought in my memory, at that time there was a battle between Ackerman, the NPA, the police and others, and they have different approaches. And the Celebi, for instance, would say the Reverend doesn't want people to be prosecuted. Piccoli would say, you know, he hasn't said that. He's allowing the NPA to do their job, which is my attitude. It was that. So if they come with a piece of letter to sign that they are going to do what they are going to do, my view was, I'm getting into the conflict. I don't want to enter in that space. I said to him, the NPA has a right to decide to prosecute. I don't have to make that decision. And I'm not opposing them doing it.
Can I read to you, as a Muruti who's a lawyer, what the Criminal Procedure Act provides?
Yeah.
At section 105, capital A, 1B, and Roman letters 3. And then ask for your comment. And this is about plea bargain.
Yeah.
It says, let me start here. The prosecutor may enter into an agreement contemplated in paragraph A after consultation with the person charged with the investigation of the case. And then it talks about what are the circumstances that must be taken into account. But then at 3, it then reads, after according the complainant or his representative where it is reasonable to do so, and taking into account the nature of and circumstances relating to the offense and the interests of the complainant, the opportunity to make representations to the prosecutor regarding AA, contents of the agreement, and B, the inclusion in the agreement of a condition relating to compensation. Would you say that any of this happened before and at court?
Yeah, no, I'm relying on memory now, but let me just say, firstly, it was the first time I deal with plea bargain stuff. It's not in me. What I know is that if you say he has been consulted, there would be a statement you do to confirm what I understand it as a confirmatory statement to say, I have been consulted and I agree and etc., whatever you do. But that note was not about that. It's a pity we don't have that note. That note was almost like agree with him about what he's going to do. I shouldn't see that document, and I have not done a confirmatory statement. That's really my understanding. I'm not a lawyer, so it's a bush learning about it. So I can't say that. But one thing sure is that I was not given an opportunity to have a confirmatory letter and affidavit about what they are saying about me in that statement.
If I may, Chair, direct it to a page that I need to. My apologies, Chair. 158. Oh, thank you, Chair. I've just been handed up, it's 159, page 159. If you could go to page 159
Yeah.
of that bundle.
Yes, that's the letter to Vusi Pikoli.
And this was the letter you were supposed to sign.
Yeah.
So it has nothing to do with seeking your views in terms of the section that I've just written to you.
Yeah. Ma'am, I saw this letter early morning today, and I thought it was an interesting letter. But in that environment, I would not have been given the letter myself to look at it. I think they came and said, "Can you sign this?" I say no.
I'm asking a different question.
Yeah.
That you can. And I nearly said it in Setswana. What I'm trying to say is, the letter. You remember, I read the section about consulting with impacted parties, as it were,
Yeah.
victims like yourself. And the section makes provision of your views being sought. You remember I read that to you. In respect of the plea bargaining.
Yeah.
The question that I'm asking you now is, this 159 is not about that. Would I be correct to say that?
I'll have to read it again, ma'am.
Please do.
Yeah.
Do you want me to read the section again?
Yeah, no, the letter.
Okay.
Yeah, maybe read it aloud, sir. It's just a short letter. Reverend?
Yeah. It says, at the conclusion of my meeting with Advocate Ackerman of your office, I deem it imperative to convey that the independence and discretion of the National Prosecution Authority in deciding whether or not to prosecute in any given matter should not be impeded. This view pertains to the above matter too. Should your office exercise a discretion in favor of the prosecution against the above perpetrators, I would not have any objections thereof. Now,
This was written on the 19th of January 2007 by yourself.
no.
No, Chair.
No.
Am I missing something? Sorry.
Yes.
I also missed it when I read it this morning to say, is this my letter to
As
Vusi
I understand,
Pikoli?
Advocate Moroka, all that you are trying to ascertain is whether what you have read to the witness with regard to the plea bargain requirements is what is contained in this letter.
And more specifically, was
The need to
conveyed at
consult.
the meeting. Yes. Chair.
Yes.
Thank you.
Okay.
Yeah.
Yes.
No, I read it like a new letter this morning because that time the environment was not conducive to this.
Yes.
I also thought it was my letter
Yes.
when I read it to say, I wrote a letter like this. Oh, it's not a problem for me, but it's clear that they drafted the letter, came
yes.
with the letter.
Yes.
And it's at that point in our discussion where I refuse to sign it because, I don't get a letter written for me and sign it and let them walk away with a letter. I have to apply my mind. But in our discussion, I made it very clear, which is in this letter. I made it very clear. I'm not standing between you. Your work. You do your work. You don't need me to say prosecute. You do your work. But this letter is not about me saying you can continue prosecuting, because I didn't think I need to give them that permission.
That is why
Yeah.
I'm focusing your attention to the section that deals with plea bargains and deals with victims.
Yeah.
That this letter had nothing to do with that section.
Yes.
Do you understand what I'm saying?
No, I can
I see your
understand.
face.
Yeah, I can understand that, but I was not even aware of that section you're reading. So mine was the discussion in that room.
And
Yeah.
if I may follow up, Tate Moruti, is that at no point before or after this letter do you recall an exercise until you say the intervention of Mr. Piccoli,
Yeah.
an exercise in terms of what I read to you in the Act?
No.
Thank you. So if I may turn to the Alata bundle, and I want a timeline about consultations and the plea bargain. I'm still on that topic.
Yeah.
I ask you to turn to page 145.
Yeah.
Remember, it's now common cause, I would imagine, that this meeting with the tea and biscuits was in January 2007.
Yeah.
At page 145, para 298, this is what Mr. Piccoli has to say. Towards the end of January 2007, Advocate Ackerman and Advocate Maga reported to me that they had met with the Reverend on January 22nd and that he reaffirmed his consistent attitude, namely that he was not against a prosecution and that the matter should take its ordinary course. You agree with that?
Yeah.
But then Mr. Piccoli makes reference to the timeline that I want us to talk about at paragraph 300, page 146,
Yeah.
where he says, remember you have the meeting in January 2007, and he affirms that there was that meeting, and affirms that you said you had no objection to the prosecution going ahead. At 300, he says, during the course of the next few months, the legal representatives of Otto Smith Staden had detailed negotiations with Advocate Ackerman and members of the PCLU in regard to a plea bargaining and sentencing agreement. Do you see that?
Yeah.
So in January 2007, the negotiations had not started. They start a few months thereafter. Do you see that at 300?
Yeah.
And then he says the matter was set down on 17 August 2007.
Yeah.
And then it says at the same paragraph 302, there's a paragraph missing, Chair. At page 147, He says that it informed her, Mr. Piccoli now writes to the minister to inform her of the fact that plea and sentencing agreements have been entered into,
Yeah.
and that this letter is signed on the 10th of July. Do you see that?
Yeah. I
And,
am.
and so the letter gets signed on, you get consulted on the 19th of January.
Yeah.
The letter gets signed on the 10th of July,
July.
2007.
Yeah.
Would I be correct to say that during this period, there was no interaction with you about the plea bargain?
No.
According to your recollection.
My last discussion with Ackerman was that unfortunate meeting we had. And as far as I remember, Piccoli intervened, and he's the one who told me about the plea bargaining arrangement. I think it was by telephone, actually, informed me about it, and then there is nothing that happened between me and them in terms of details. I don't remember that.
So when Mr. Piccoli says towards the end of January 2007, Advocate Ackerman and Maga reported to me that they had met with Reverend Chikane on 22nd January and that he reaffirmed his consistent attitude. It was not about the plea bargain.
No, yeah, it's about prosecution.
Thank you.
It was about prosecution. And I've not changed. It was consistent that I won't interfere with the prosecution authority. But remember as well, although it's personal, but I'm in the president's office, so I need to work within the law and respect the prosecution authority in that.
So finally, it's correct that your statement when you say that regarding the plea bargain and sentencing agreement before it was concluded, you are not consulted, is a correct statement.
In the manner in which I expected it. That I can't say Piccoli did not consult me. I can't say that because he talked to me by telephone. But what I'm talking about consulting, it's my view about the plea bargaining detail itself, because I expected that to be done.
That's what I'm talking about too,
Yeah.
Muruti, because that's what the law expects to have happened.
Yeah.
Thank you. If we can move to your letter to the minister,
Yeah.
Minister Mabandla. You've given evidence of that letter. It is common cause. The letter has been given in evidence. Would I be correct if I say to you that your intention of writing this letter was intended to help the performers to do better next time?
That's correct.
And it was an after-performance exercise.
A what?
An after-performance exercise.
Yeah, it was
in
an
government
evaluation.
circles, it's called debriefing of sorts.
Yeah.
And that you say you raised issues that got lost in the battles. You say that in your book too.
Yeah.
But essentially, what was the nub of your complaint was that you were of the view that it was the wrong people who'd been assigned to do the prosecution.
That's correct. And I was saying, I don't want other people to go through this experience. That's really, and I expected them to act on it urgently because others may go through the same experience.
But that the prosecution of evildoers must continue.
Yeah, that was not the debate. It was the manner in which it's done.
Can I go to a completely different question, if I may? Dr. Homer said it in Setswana, I can't remember what he said, or let sleeping dogs lie.
Yeah.
And you say in your evidence and in the transcripts that it was can't remember the word, I'm sorry, but it was not an official position of government, was it?
Yeah, no, I talked about this in my earlier evidence, and I've said there were...
Sorry, I said in Setswana, squad society, let's say.
Thank you, Dr.
Dietsang.
Home. Let's say.
Oh, yeah.
Didn't just say let's say.
Yeah, machika no tlan thusa ko gae. No, it's a Tswana expression, yeah, and she's Tswana speaking.
But you understand
But
that?
it makes sense, yeah. Uskatso satse let's yeah.
And you say, Muruti, that you were when you talked about the debates and the conversations and the atmosphere and the attempts at the time to build a new dispensation for our country, there were all these competing views and competing pulls and pushes factors.
Yeah.
And you say that, and then you say that a number of the ANC people were of the view that Adilai, also
Some.
some.
No, some.
And that's where I wanted us to go to.
Yeah.
That it was never a government policy that let sleeping dogs lie.
No, it was also not the organization's policy. It was a debate. And you'll have different views about this. Some people would say, we have reached this stage, we don't want to continue the war. Let's use what we got. It will take time to transform it, but you can't go where the former generals wanted us to go. If you're going to prosecute them, they're going to destabilize this process. And that's why the debate about charging the 37 and using it as a threat, there were people like that who felt, let sleeping
Dogs.
yeah, lie, or say that's the English version of it. I mean, there were many debates about that. For instance, when P.W. Botha defied the government and didn't go to court at one stage, something like that, there was a huge debate to say, do we lock up this old man? You know what I'm talking about. Do you lock him up? Others would say, yeah, lock him up. Others would say, no. It's a waste of time. It will destabilize the country. He's so old in any way. Why do that? So those debates would happen outside the formal process. But in terms of the law, nobody said, we make a decision, we're not going to charge people. Where we have evidence, I keep on emphasizing this. Don't charge people because you suspect them that they poisoned me and charge them. You must have evidence to win the case. So there will be those who are saying, no, don't charge them like me. Charge them for the sake of charging them. You must have evidence and then put the evidence to court. Others would say, no, follow the law, just charge them. So there were many debates, but there was no policy position. I have my own view, and my view is, if you have evidence, charge them. But don't use suspicion. even intelligence, you must translate intelligence to evidence. Court doesn't work on the basis of intelligence. You must translate the intelligence into evidence. And that's what I was trying to do with my case. The other guys, where they had enough evidence, why don't you do it? Those who differed with me, because it was a personal issue, they were saying, Reverend, your approach will destabilize the country. And I'm not saying government or ANC, it's individuals. And I was saying, no, but I just want the evidence to be put in court, then I can use it. Otherwise, I'll be sued if I use it. I think that was the argument. So I can't say there's a government decision to go this route or that route.
Finally, if I might ask a final heading,
Yeah.
it is about the ANC 37. You know of those. And you know it's common cause that they were refused
Amnesty.
amnesty.
Yeah.
And there's always been talk, sorry, my battery is dying, talk that it was always used, the threat of prosecution was always, there are those who charged that the threat of prosecution was always used as a lever or leverage to make sure that that prosecutions do not occur,
Yeah.
because the other side would say, we know more about you than what you know, and if you go after our people, we will go after you. You know those conversations and
A bargaining chip.
the
A bargaining
the bargaining chip or the leverage chip. You know about it. I would assume you know that and I'm going to refer to you, Mr. Nguka at page 85.
85. Yeah. Okay, up there.
Released a media statement. Do you remember this? Have you ever seen it?
Well, I saw it today in the morning, but I mean, I wouldn't have remembered a particular statement, 15th May,
No, well,
2004.
maybe let me rephrase it. I wouldn't remember too. We are at a,
Yeah,
I won't call it advanced age, but at an interesting age.
yeah.
But did you know that at a particular point in time, being in government, that the so-called 37 were not susceptible to be charged because Mr. Nguka had taken a decision that there was no case against them. It says decided not to launch any investigation into the ANC 37. Did you know or didn't you know?
No, in terms of timelines, no, I wouldn't know that. But even if that was the case, suppose it's on record now. Even if it was the case, you know, the law in this country, somebody can do private prosecution, can do a number of things. And you would have, of course, if you do that, get the NPA declared, there's a legal way of doing it, declare that they are not going to prosecute, and then you get the possibility.
The so-called nolle prosecute.
Yeah. So I don't remember that statement myself, but we worked on the basis that threat was still there after 2004. You remember even when we discussed these issues about plea bargaining, the debate was that if my case continues, it will trigger. And there were threats that trigger will come from, is it Wagenaar? Now I'm getting used to his name. And they had files. They had infiltrated the ANC. They had files of the minutes. And they have left them with, I was told, they left government with those files. They are elsewhere. And they are ready to charge this lot. So that fear was there. I saw that, Ackerman does refer to this matter to say it was, people believed it. Well, I believe that anybody could do anything to destabilize us at that point, during that time. But I don't remember.
But you accept that Mr. Nguka, he's been called an advocate in these proceedings, but he's actually an attorney. Mr. Nguka had made a decision as the NDPP.
Yeah, I wouldn't be surprised.
You make reference, even though tangentially, to this issue at page 11 of your evidence at para 32. Para 32.
Page 11.
11.
Yeah. Yeah.
I don't know who's faster in reading, me or you, so that we can.
Yeah, it's page 11. I've got it.
Paragraph 32.
Yeah. Yeah.
So you see that in the middle of the page, you say that certain members of the prosecuting authority wanted to arrest and charge the 3 police officers who had been identified as being involved was part of the strategy to precipitate action against some of the leaders of the new government, especially the 37, whose application for amnesty was turned down. Such a result could be achieved in the name of equality. But the facts do show that there was no such fear, because Mr. Nguka in 2004 had already taken a decision.
Yeah.
But you can't comment, you say you don't recall.
Yeah, I don't recall, but I can comment based on the information before us that you couldn't use this technically to say, because Mr. Nguka as an NDPP did this, it would stop everybody from doing the things that they could do to destabilize you. Remember, those who destabilize don't use the law, basically. And if they use the law, it will be, again, using the law to destabilize you. So they use me as an example. There was no time at which I believed that there would be no destabilization. I mean, we went through this experience. We had, Meiring, and you know that big story about Mandela giving Mandela the wrong information and to influence him to do certain things. You can see as well in Madlaga. So we have an integrated system, intelligence, police, no, actually the military, the police. The liberation movement was practically absent because they never trained police. So the suspicion for me would not have gone away. The feeling that somebody will destabilize us didn't go away because people meant, it was planned. I don't want to go into politics now. They would have been foolish not to plan to destabilize us once we've taken over. It's impossible. They would have been foolish. So I worked on the basis that there's a risk. But it doesn't mean that that note didn't exist, no.
And therefore, can I refer you to paragraph 85 of that media release, the last paragraph, page 85, the bottom thereof,
Yeah,
that the Foundation for Equality Before the Law, an organization led by former National Police Commissioner General Johan van der Merwe, which mainly comprises former members of the old security police, sought to use the TRC judgment to call for the prosecution of the ANC leaders. So this, in a sense, resonates with what you're saying.
yeah.
Chair, that will be our cross-examination of this witness.
Yes. Mr. Vani, I think this might be an appropriate time to adjourn for lunch until 10 to 2, so that you can commence with your cross-examination without interruption.
As the Commission pleases.
Yes, we are adjourned until 10 to 2.
Okay.
Mr. Vani?
Thank you, Chairperson. Just one small housekeeping matter.
Yes.
My learned friend, Ms. Morocco, made reference to the fact that there was a page missing from the affidavit of Advocate Bakoli. That was his affidavit before the Ginwala Commission. We have found the missing page. We've distributed copies to all the parties. We just wish to check with the document manager whether the Reverend Chikani and the commissioners have also received it.
Thank you.
Chairperson, we will make reference to it later this afternoon, but just for your records, we suggest numbering it page 146A of the cross-examination bundle.
Yes.
With the Chairperson's leave, I'll commence.
Yes, you may comment, Mr. Vani.
Thank you. Reverend Chikani, I think I need to disclose that we have a prior history going back some years. And in fact, when we were chatting earlier, that history might go back to the 1980s, when I was at Newtown University, and I think we might have invited you to speak at one of the meetings on campus. And then in the early 90s, when there was conflict in KwaZulu-Natal, you formed a committee at the South African Council of Churches dealing with the political violence. And you invited me to serve on that committee. And I'd like to say that it was a pleasure and a privilege working under your direction. And I attended several meetings at your office in Johannesburg in those days. And then more recently, I called you as a witness for the family in the Neil Aggett case, where you gave important evidence dealing with your experience at John Vorster Square, including your torture. And again, we'd like to thank you for your contribution in that inquest. We understand what you had to go through. From the perspective of the families, we recognize you as a witness, and we want to thank you for the sacrifices that you have made for the liberation of South Africa. I just wish to place on record, Chairperson, that the Reverend has testified now on the Suka affidavit. He's put up his version. We don't intend to take that matter any further. Both versions are now before this commission, and we won't be dealing with it in this cross-examination.
Yes.
Reverend Chikani, just to give you a sense of how we're going to run the cross-examination, we're essentially going to take you through certain paragraphs of your statement, and then also perhaps a few extracts from your evidence in chief, as well as some of the evidence you've given this morning. You'll notice that sometimes we agree with you, and at other times I'll be putting the version of the families to you for your response and comment. And just a reminder that when you testify, you have to address the commissioners and in particular the chairperson. Thank you. If I may, I want to take you back to the manner of elimination that the security branch selected in your case. And in your matter, they didn't do what they had done with so many others, which, for example, would have been a shooting. They decided to kill you through poisoning. And I understand that the poison in question, the technical term, is organophosphate, sometimes known as peroxin. Is that your recollection as well?
Yes, it is the general description. It's organophosphate-related chemicals, and the paraoxin, it's one of those types of chemicals. It's in the submission by Flock and Hele in that. So in the actual order against my name, it's paraoxin or something like that.
Yes.
Yeah.
And we did some research on the symptoms of this poison, and it can mimic the symptoms of a severe stroke.
Yeah.
You're aware of that?
Yeah, well, I don't know the details, but I know that once I got into contact with it, within an hour or so, I would be on the floor without being able to lift my limbs. It's absorption. Yeah.
And you've also testified around the fact that you were treated at a hospital in Wisconsin by people, medical experts, who could detect what had happened to you, certainly after your suspicions had been raised. And that but for that treatment, you would have died.
Yeah, actually when it started, it was for the second time because it hit me here in South Africa first, no, in Namibia. And I was flown back to South Africa. That was the first experience. We didn't know what it was. And I went to the US. We're going to campaign for comprehensive sanctions with the older Bush. There are two Bushes presidents. And the few of the viewers, why can't he go and join his wife for a few 10 days or so before that meeting, rest? And I went there, and it hit me the first day after arriving a day before. The following day, I ended up in a Catholic private hospital. That's where I lost consciousness and etc. And then after that, every 36 hours, I would be hit again. So they had 5 underwears where they put this chemical, so it rubs against you once you put it on. And it would take me out. So in a sense, I think if I didn't have the attention that was given to me, I would be dead. Nobody would have known how I died. And in Namibia, there were 2 Lutheran church German doctors, and the hospital stopped for 5 hours because they were battling to keep me alive, and then flew me to the SABC, took me to Johannesburg, Nightingale Clinic, to be taken care of. So all that wouldn't happen for an ordinary person. He would have just died on the north of Namibia. That was the plan. Go past the hospitals, get hit where there were no hospitals. It was well planned. I would have died, but it hit me just 20 minutes before the last hospital, because we stopped on the way to have breakfast.
Thank you.
And that's what saved me.
Thank you. Thank you for that harrowing account.
Yeah.
Would it be fair to say that those who were plotting to have you dead wished to conceal the methodology? They wished to give the impression that you died of natural causes, either through a stroke or some other kind of disease, and thereby your death couldn't be connected to the security forces?
Yeah, that was the plan, because it was only found out when I had the 4th attack, but now in the US. And they happen to have people who have dealt with chemical weapons attacks, and they had a way of detecting it. That's how we got it.
So it can be accepted that the security branch at the time had this pernicious method or approach of targeting opponents of apartheid and eliminating them by giving the impression that they had an accident or they fell ill.
Yeah, I don't want to speak too much about it, but let me just say, besides the list of chemicals, which are at the back of my book, I felt we must attach them coming from that case. My name is against one of them, but there are about 49 or so orders with dates. Nobody has said who were they used against. And my assumption is that people died. And we don't know who in exile was also attacked in that way, because the plan was those outside and those inside. So I would imagine many people died and nobody knows.
Thank you. Can we just turn to your statement, to paragraph 21, which is on page...
My statement,
Yes, your statement. It's on page 7, paginated page 7.
Yeah, 21. Yeah.
So perhaps I'll just read into the record an extract. Unfortunately, some parts of the TRC recommendations were not acted upon as recommended by the TRC or in the form in which the TRC recommended for various reasons. Some would be that government modified the recommendation, e.g. the quantum of the grant to victims or the definition of victim who qualified for reparations in terms of the TRC report, or because of failure of the system, or because of the political complexities of the time. And then, if I can just jump to paragraph 25, you state the part I got involved in relation to the post-TRC matters as the Director General of the Presidency and Secretary of Cabinet was in discussions relating to the magnitude of the grant, in brackets financial, to victims as defined by the TRC cases. So this question around the definition of victim, would I be right in saying that you were referring to the victims who qualified for reparations, those who were on the TRC list of victims, sometimes referred to as a closed list?
Yeah. Yeah, that's really, I'm saying this is the only part I got involved, because the issue, the way it was framed, I don't remember the exact words now. It was almost like those who appeared before the TRC and those who were mentioned as victims. If you did not mentioned, then you wouldn't qualify. That would create, I qualified because I was mentioned many times. I didn't go to the Truth Commission because I didn't think it was necessary. But then the debate was, we can't work on the basis of figures you wouldn't be able, because it would be millions of people who were victims. And that's where the debate about the definition of a victim was about.
I see. So it was discussed about the possibility of opening that list to others who didn't make it to the TRC, but the feeling was it would be, there would be millions.
No, actually the view was you couldn't exclude people because they didn't appear at the Truth Commission. Then it's unjust. Because there are people who lost families, who died, people who were tortured over the years. And you couldn't adopt a policy that creates an injustice within and amongst the victims. I think that was the debate at that time.
Thank you. Just one small correction. The figure you mentioned of 600,000 per person, my recollection is that it was 30,000 a person.
No, the 30,000 was the revised figure. So the people, after that debate, instead of giving the victims 600,000, which was recommended by the Truth Commission, people were given 30,000 as a symbolic thing, because I said you can't pay for my pain. It's impossible. Even if you gave me 600,000, it wouldn't pay for my pain. Yeah, that was I think it's 30,000 after. You can check that.
That was the grant that was actually made. It's strictly speaking not part of this commission's mandate, so I'm going to move on. Although this commission has been asked to look into the question of constitutional damages, but I can tell you that the same debate as to who qualifies is still raging even today.
Yeah.
Perhaps let's move on in paragraph 25, also at the top of page 9. You indicate that you were involved a bit in other matters as well, besides the financial grants, and this is the last line of the paragraph. These were the cases of people who were denied amnesty in terms of the TRC Act and those who did not appear at the TRC hearings. Would I be right in saying that the discussions you had in relation to those aspects ultimately led to the decisions that in turn led to the guidelines, the TRC guidelines?
No, I wouldn't be able to say the sequencing those matters, but when a commission makes a recommendation, the state looks at it and decide how they implement it. And other discussions happened at other levels where I was not involved. But the issue about the guidelines, whatever the language, whether it's the first and second document, it was an attempt to prescribe how you implement the decisions of the Truth Commission. That's all I can say about it, but I didn't get involved.
And can I ask if you can recall approximately, at least in the discussions that you were involved in, that you refer to in paragraph 25, approximately when were those taking place?
Following the report and the president going to parliament, I would know within, but it was immediately after.
So approximately 2003.
After the report, yeah, I would know.
Thank you. And can I also ask you to think back as to when government began thinking about and discussing the formulation of guidelines to deal with the TRC cases?
Yeah, I can't put time because I think once the president received the report, discussions began. They had to begin to talk about how we're going to deal with this matter. I would be involved where the president invited me to be there. But otherwise it's other ministries and DGs. But it was immediate because the president had to go to parliament and make a statement in parliament. Now I don't remember between the report and the parliament what happened and what time was involved. I wouldn't remember. But the president had to, I got involved insofar as the speech, when they write a speech, I would see the speech because I'm the head of that office. I needed to see the speech, even if it came late, but that's when I become relevant.
Thank you. And do you have a recollection of who initiated the discussions around the guidelines?
No, I wouldn't.
Can I refer you to page 44 of the bundle? This is, it appears to be a cabinet memo. And I just want to refer you to paragraph 92 of this cabinet memo.
9.2, yeah.
9.2. And it reads as follows: prosecutorial policy and directives relating to the prosecution of criminal matters arising from conflicts of the past and which were committed before 11 May 94. And then in brackets, there's the small print, which, let's see if I can decipher it. It reads Cabinet Memorandum 4 of 2005, dated March 2005. Then it gives a reference number. And then I'm going to jump to the last line there. It says, refer to item 3.2.1 of the minutes of the Cabinet dated 18 April 2003. And then in this memo, it then approves the prosecutorial policy and directives. But just going back to the small print in brackets, it appears that this issue did serve before Cabinet on the 16th of April 2003. As Cabinet Secretary, would you have been present at a meeting in April of 2003?
Yeah, I mean, I would say it's likely that I was present because I was present in most cabinet meetings, but I wouldn't say I was present in all the cabinet meetings because at times you're traveling and you're not there. The deputy takes care of the business. But yeah, it's a cabinet minute, and I noticed that it's declassified.
Yes. Just to be clear, this particular minute is from 2005, but it makes reference to item 3.2.1 of the minutes of the Cabinet meeting dated 16 April 2003. And the point we wish to make is that was one day after President Mbeki's speech on the 15th of April.
Yeah.
So it does appear that the guidelines were discussed within a day, although they're not referred to as guidelines here, but we colloquially do refer them to as guidelines, but here they're referred to as prosecutorial policy and directives.
Yeah, I didn't apply my mind on when I read it on the date. But I mean, these events were immediately after the report of the Truth Commission. This is like 2005, date of this document, 22 June 2005. They would have been discussing, the discussions were much earlier. I don't remember the date of the report, of the submission of the report to the president, but it can't be that nothing happened between then and 2005. So some things would have happened.
Yes, yes, indeed. I don't think there's any dispute about that. The only point we make is that this minute refers to earlier minutes of the Cabinet on the 16th of April 2003, one day after the President's speech in Parliament. So it does appear that within 24 hours the issue did serve before Cabinet.
Yeah, I can't deny that, because if the President made a statement, it would then go to Cabinet. How many days after?
1 day.
Yeah, it would be impossible to do it that way, because then they would have started 2 weeks ago before the President spoke, if that's the case. Because you go into Cabinet committee before you go into Cabinet. So it's a cycle of 2 weeks. It couldn't be the following day. So whatever the story, the point is, if that is the date, it would have started 2 weeks before. And it's very possible that the President, the Cabinet makes a decision on this matter, and then it goes to Parliament, not Parliament to Cabinet. I think the other way is more likely.
Thank you. And yes, as you say, between 2003 and the ultimate promulgation or proclamation of the guidelines in December of 2005, there would have been all kinds of deliberations, as you allude to. Can I ask, in the course of those deliberations, were you aware whether victims or the victim community more generally were consulted on the guidelines before they were promulgated?
No, I can't say. I mean, there must have been consultations, but you know, consultations are limited. You can't consult all the victims of apartheid. It's impossible. They might say they consulted some people. I have no idea. But the consultative process in government was an accepted way of doing things. Whether this one happened that way, no, I wouldn't know.
Well, it is a complaint by the families we represent that that they were not consulted, and there's no evidence that we're aware of as yet that any other victims were consulted. And my attorney advises me that Advocate Pakoli confirmed in his evidence that victims were not consulted.
Yeah, I think refer to people who were in the game at that time. I wasn't there. I wouldn't have gone into processes. So it must be the departments that go into consultative processes. I can only say from my point of view that there were many victims listed in that.
Your voice is dropping a bit, Reverend. Maybe because you're supporting your back, you've been sitting for a time. If you can pull the chair.
Yeah, no, that's okay. I got the chair changed. Yeah, no. There was a long list of victims. And, you know, the issue of consultation can be debated. I think people who did the laws or took things to Parliament or Parliament, consultations would have been done normally via Parliament, you know, at a parliamentary level. That's where normally, I mean, the departments could do them differently. But I'm not the right person to check. I think the people who were involved here were National Prosecution Authority and the DGs and the ministers can confirm that. But I would
Thank
be
you.
the person. Yeah.
Thank you, Reverend. Am I right in saying that you were not personally involved in developing the guidelines?
No,
Thanks.
it was far from me. Remember, we were working through clusters at that time. So we had social justice and safety, we had economic and all that. And and when there's cross-cutting issues, they will be dealt with by different clusters. But I chaired the FOSAT, which was a forum of directors general of South Africa. So we wouldn't go to, I don't go into the clusters unless I'm invited.
Thank you for that clarity. Let's turn to the next paragraph, and I'll just quickly read it into the record.
Page.
Commissioners, that's paragraph 26 on the same page.
What page?
Which page?
Page 9.
Oh, page 9.
So it reads, on prosecutions, guidelines were developed to allow a possibility for those who were prepared to disclose what they did to arrange for a plea and sentencing arrangements to dispose of their cases. Affected victims had to be involved and consulted. This is the approach I used in my poisoning case. Now, if we were to look at the guidelines and how they were applied in your case, my understanding is that the application that the accused made and then the ultimate plea and sentence agreement, there were two separate processes. That Mrs. Flock and Van der Merwe and the others applied to the NPA in terms of the guidelines for a decision not to prosecute, and that ultimately their application was rejected on the basis that they didn't disclose in full. And then the subsequent to that, just under the Criminal Procedure Act, the plea and sentence agreement followed. Is that also your understanding?
Yeah, I can only speak from my point of view in terms of the process. I understood that an arrangement would be made for those who did not appear at the Truth Commission or who want to disclose what they've done to make sure they get amnesty, because if you don't and evidence comes later, you get charged. That was the logic. And so for me, it was that process that we were following, but using the plea bargaining approach where you don't have the evidence and they have to give you the evidence. And that's where the bargaining comes in. And that's how my matter was dealt with. I used that to say, if you disclose everything that I need to know, you can do a plea bargaining, but it's not with me. It's with the prosecution authority. It's not, yeah. That's why when they got into trouble, they came to me and I said, I can't help you. You know, it has to be done through the prosecution authority.
And just sticking with the with the guidelines, the guidelines were essentially formulated in three parts. The two important parts were Part B and C. Part B allowed for a procedure by which people like Flock and Van der Merwe could approach the NPA and seek a decision not to prosecute on the basis of criteria that was set out in Part C. Part C set out special criteria that applied to the TRC cases. And that's exactly what the suspects in your case did. They approached the NPA, invoking the criteria and seeking a decision not to prosecute, although that was ultimately unsuccessful, which then led to the normal process of law under the Criminal Procedure Act. Am I stating it correctly?
Yeah, I can't talk about what they did with the prosecution authority. I can only talk about my engagement with them, that we moved from, they went to the NPA first and came to me when they failed. And they still were arguing for an amnesty and this and the other. And I said, that's not my area. It's with the National Prosecution Authority. And they tried, failed. And then when they came to me, it was more about, I just want information. And if you've given me the information, you can go to the prosecution authority. That's the process. And the prosecution authority will decide about that matter, not me. But I don't know what they followed on the other side. Yeah.
Yes. On the question of the guidelines, a question arises given that President Mbeki had spoken about using the normal processes under the criminal law, and I think you've also made reference to that. And one of those normal processes would be using a plea bargain, such as a plea and sentence agreement. That being the case, why was there a need for a special approach as under these guidelines when you could simply have used the normal processes under law?
Yeah, let me just say my understanding. There might be other people who understood it differently. My understanding is that you were created, that's why I use the word guidelines, maybe it would be another one. But my understanding is that you were documenting a way in which the post-TRC cases can be managed. So it's a process, but it doesn't change the law. So use the law. And that's what I did. I didn't operate outside the law. But it's special in the sense that it's about TRC and they can do it in that way. When I wasn't dealing with an ordinary criminal case, in a normal criminal case, they will use the law in any way. But we couldn't do anything outside the law.
Thank you. Let's turn to a new issue which you refer to in paragraph 27. And here you unpack what you refer to as the political complexities. Perhaps I'll just read this paragraph into the record so we can be on the same page. The political complexities which bedeviled the prosecution of perpetrators of gross violation of human rights related mainly to the need of the old order to protect its commanders and foot soldiers, especially those who were at the forefront of committing these dastardly acts, and the equalization of violence in support of the apartheid system and armed resistance to end the apartheid system. There were threats that if the apartheid order operatives were charged, they would also charge particularly members of the National Executive Committee, the ANC, especially the list of 37 that did not get amnesty in terms of the TRC Act. There was a story that the old order operatives had files of minutes of the ANC NEC in exile, which they would use to prosecute leaders of the ANC. So we think that you have very neatly encapsulated the political complexities, to use your phrase, the dilemma facing government at the time. that if prosecutions went ahead, for example, of the old order generals, then there would be pressure on them to also go after the ANC. I think you describe it as equalization. So would I be right in saying that this was in fact the real reason for the sensitivities around these prosecutions?
Yeah. How do I put it? I thought that paragraph puts it better than I can explain it. See, we have political complexities. This is not just a criminal matter and let people be charged, etc. It's a transition from one apartheid system to a democratic society. And you are managing the transition. So I would like to call it management of a transition. How do you manage? If it's a coup, it's a different matter because you just remove the people and substitute them with others. In this way, we manage in transition. I was in the first electoral commission, and I always call it a commission that managed transition rather than just an election. It wasn't a normal election. So that's the complexity. If you take it as a technical matter, it's a just transition from one government to another. But this is complex. It was a complex matter. And even the TRC was a compromise. When I talk about equality, our TRC was going to be how you deal with the perpetrators of human rights violations and the military generals who killed people in a struggle where it's violent. How do you deal with it? And our original design was that it was about these generals and everybody. What do we do? And how do we get reconciliation? But they fought back and did this equalization. We'll treat you the same, you killed us, we killed you, and therefore equalize. So the outcome, that act, was not what we asked for. But they also say that's not what they asked for. So that's what the complexity is about. It's not just about the outcome of the TRC, it's the whole management of the transition. And we created structures that are strange as well to go through the transition.
So thank you for explaining those complexities.
Yeah.
Let's then turn to the next paragraph. That's paragraph 28 on page 10. It reads, in the light of paragraph 26 above and the fact that we ended up with a political settlement, there was a view which was not codified officially that we should let sleeping dogs lie to avoid destabilization of the new democratic order. Among those who thought like this, as I've said in my book, things that could not be said, there was not much appetite for looking back. Now, firstly, when you use the phrase, we should let sleeping dogs lie, in this context, am I right in saying that you're really saying that there should be no prosecutions at all?
Yeah, I want to repeat again this sentence because the phrasing, it's keep it as some thought like this, others like that. And whatever it's expressed, it's not an official view, it's the views of some. And I respect all those views myself because there were genuine people who were saying, we've had a democratic election. Let's normalize the country and not go backwards, because going backwards will destabilize. And these generals were determined, and there were two levels of negotiations where there was CODESA, but there was another level of negotiations with the generals, because they are the ones who were threatening the stability. It didn't matter what agreement you had in CODESA, but they were the key people, and those had to be managed. So I think they were genuine people. My approach is that I can't say that these were bad people and those were not bad people. They were trying to manage a complex transition. And there were those who said, no, you can't do it that way. We want a full process of charging all these generals, on the other extreme. And mine was, if you have evidence, charge them. You don't need anybody, But the people who had to manage that are the old order people as well, the prosecutors at that time, the police, the judiciary. We inherited all that. So that's why the debates. But my view was, there's no debate. If you've got evidence, charge them. If you don't try it, because they will be acquitted, and then you have no leg to stand on. They are innocent. And
Thanks, Reverend. Can I ask you, do you perchance recall who was advocating to let the sleeping dogs lie?
No, I wouldn't want to. These were in informal meetings and discussions. It's not official. So there was no formal process. You listen to everybody. When I dealt with my matter, we're in a DG's forum and it's during lunch and you debate these issues. But they don't turn into an official story. And I put my case that I want to know, so you can't say that I can't do it because it will be risky and etc. I want it done. If there's another way, I'm happy to go another way, but I want to know who put this poison, what was the intention and the objectives.
As I understand your evidence, Reverend, you do recall those who were advocating for no prosecutions, as in letting sleeping dogs lie, but you prefer not to disclose their names at this stage?
It's informal discussions. I really can't go and say this one said this. There were debates and we used to differ and no, I can't go and, it's not like a meeting where you have minutes and who attended and etc. Who expressed which opinion. They have the right to express views. But what stands, it's the official position. That's what would be official position and implementation. But I can't go that far.
Right. Because such information, bearing in mind that this is an investigative, fact-finding commission, could be useful. As you've pointed out, intelligence provides leads. You could assist this commission with leads to follow.
Yeah, no, I won't be able to help you because I didn't keep records and etc. These were views. I mean, some people's views might be weird, but it's debates amongst us. Let me reduce it to a party. Dinners, this and the other, you debate. So I can't go and say, this one did this. I think we can say, what was the decision of government or cabinet? That's what matters for me. The debates are...
Thank you, Reverend. I won't press you further on that aspect. Let's move to your next paragraph on the same page, paragraph 29. There's some repetition. You make the observation that some within government and the ruling party felt we should close the post-TRC matters and do nothing further. They reasoned that by continuing with the prosecution of these matters, we run the risk of destabilizing the country. This was based on their appreciation that while the perpetrators of gross violations of human rights were afraid of being prosecuted, they were themselves preparing to arrange for those on the side of the liberation movement, that is, those who commanded or were involved in MK operations, to be charged as well. In respect of this issue, both those from the old order and those from the new order were in agreement that they wanted to let sleeping dogs lie. So I just want to explore that last line in respect of that issue. Both those from the old order and those from the new order were in agreement that they wanted to let sleeping dogs lie. Now, we did attach to our bundle a great deal of material, and because we don't have that much time, I'm not going to go through it in any detail. But for example, we did attach extracts from books by researchers and authors, Ole Bubenza and Michael Schmidt, where they had carried out interviews with some of the former generals who spoke about meetings that happened between the generals, the old order generals, and the new order, ANC figures. Were you aware that there were such meetings taking place from the late 1990s?
Yeah, I can only talk about pre-94, that there were interactions between the old and the new order. In terms of record, I mean, they would say it started around 1988, around that time, where there were pre-negotiation processes. That's what I would call them. And then during the CODESA process, I said there were CODESA processes and engagement with the generals at another level. But the ANC can explain that better. I'm not aware that there were continuous discussions beyond, but I can't say they were not there. I mean, the people were managing some of those generals who ended up blowing up things before the elections. There were bombs up to like 2 weeks before the elections. So if you are taking over responsibility for a country, you must be interested in managing that lot and making sure they don't destabilize the country. So I wouldn't be surprised that the leadership would have had interactions at that level. But yeah, I think those who have the source that where you got it.
We accept you were not part of that.
Yeah, okay, yeah.
Now, you have made reference to Attorney Jan Wagener in your evidence, and I just want to quote you a short extract from your evidence in chief in the transcript, and that's at page 48 of the cross-examination bundle.
48 or paragraph, page 48 or paragraph 48. Is it page or paragraph?
Yes, it's I'm going to start at the right at the bottom of page 48.
Yeah.
And here you're answering a question from Advocate Sony, who's asking you about a deal between the ANC and the police and defense force hierarchy. And you say as follows: yeah, I do not want to talk about Wagner because I would not have direct evidence.
What paragraph is that?
It's
Line,
it's the very last line on page 48, and then we skip to page 49 at the very top.
From
Yes.
line 22.
the last line, Reverend,
Of-
the last line of paragraph 48.
It's page 48.
Yeah, okay.
It's a transcript, so there are
Yeah.
no paragraph numbers.
I do not want to talk about Wagner. Yeah, that's the one.
That's it, yeah.
Yeah.
I'll just carry on. I'm not going to read the whole quote. Because I would not have direct evidence, but I mean, he was the key person. He was. If you tracked any perpetrator, you ended up with Wagner. And so he was part of the strategy to make sure people are not, or their people are not prosecuted. And I know a lot about it, but I mean, I do not have evidence. And yes, we certainly understand that the distinction between, information, stroke intelligence, stroke evidence. But since you indicated in your evidence that you knew a lot about it, could you share what you did know with the Commission?
It's in the course of doing my investigation about my matter that I got to know he is the lawyer of these people. When you touch a matter, you end up with him. That's why I ended up using him as the channel to go to the 3 policemen, Otto and the others. And that's why I also went through the prosecution authority, because it was Pretorius, I think, was in the prosecution authority, and I asked that they deliver the letter to Wagner, because I got to know that those people and others are defended by him or he has interest. And I didn't want to send the letters directly to those policemen because they would have said I'm threatening them. I didn't want that. So I went through the prosecution authority to Wagner. So it became clear at that time for me that Wagner is key. When they talk about the ANC 37, talk about files from Lusaka, it ends up with Wagner. That's my information.
Right.
Yeah,
And-
but I didn't know much about him.
And was it Wagner who claimed to have files or dossiers about
No,
the...
I heard about it.
you heard about
not-
that.
I can't say he did, but I heard that he is the person who's key.
And perhaps while we're on that page 49, if I can draw your attention to line 10, I'll just quote a few extracts from there on. Around 2004, my worry was that they would charge them to release them. You see, if the old order charges them, people who were in the old order, they could charge them to release them. And then a bit further down, and actually, if I can ask you to turn to page 50, from about line 5. I could, and there's a word missing which I'm going to insert, I could not dictate to them, to the NPA, the prosecutors, I could not dictate to Ackerman, but I was suspicious that he may do it as part of their strategy to negate this, and I did not trust them. Could you indicate the basis for your view that that people from the old order would be charged in order to release them.
Yeah, if you had where we were at that point, why wouldn't I think like that? Because people were marking each other. We don't want this ANC to take out power. We want to weaken it and to control them. You know, they allow you to take out power but control you. And so if we have a case where their people would be charged, and I'm not involved, I'm not the prosecution authority, why wouldn't somebody charge a person to get them out? I mean, there are cases which go to court and the government lose them, the state lose them badly. And they've not done their work, they've not done proper procedures, and then the judge makes a ruling against it. So it was a genuine fear in that context. Remember that these people are also the same people who tortured you. It's a funny South Africa where you meet the guy who tortured you working in government, police, security, and you must laugh and feel good, you know, about it, that we have solved the problem of South Africa. I think that's the problem. So I think don't take away the suspicion that that would happen. Yeah, that's me now. Yeah,
Thank you.
maybe I should stop there.
Thank you. Can I also refer you to the next page of the transcript on page 51, and it would be line 5. And I'll just read it into the record so we're all on the same page as to which quote we're looking at. So it reads, "Ja, Wagner, that lawyer, he was part of the grand strategy designed before the negotiations to say, if we get there, we are going to have to negotiate that nobody gets prosecuted. That was their strategy, all of them. And so I would not be surprised if he talked to Ackerman to dissuade him from charging the people. On the other hand, we were suspicious that Ackerman was using the case, my case, to precipitate the crisis so that they can then go and arrest some of the ANC leadership." So that is quite a bold statement to make. And I just want to put it to you that that we don't believe there's a proper or coherent basis to make that statement against Ackerman. After all, this is the prosecutor who prosecuted people such as Eugene Terreblanche, Wouter Besson, the suspects in the PEPCO 3 matter, Ferdy Barnard, as well as Eugene de Kock. So given his history, was there any basis to have the suspicions that he wouldn't want to do a serious job?
Yeah. I think place me at the time when we were dealing with this matter, not in relation to other cases. We could talk about it. I was not thinking about any case. I was thinking about that moment and what we were dealing with at that moment. That's what I am referring to. I didn't do research and say which case, that case. It would also depend on the timing of those cases. When did they happen? Timeline. I didn't do that. I was dealing with the reality that was facing, and I'm describing a moment in history, not now. I didn't go and do research. I reflected on a moment in history.
Yes.
I may have been wrong, but that's how I thought at that point.
That was not your thinking on the 19th of May 2026 when you testify.
Yeah, we're still in a difficult corridor. And up to the time I left government, I mean, as I'm saying, I don't want to go into politics now. They infiltrated us in exile. I was here. But they infiltrated the ANC. They were managing even what some people were doing. And in the things that may not be said, that book, I do have a chapter there where I said the old is corrupting the new, and the next was the people who were infiltrated there were activated. It's in the chapter of my book. So we're not dealing with a clean operation, easy. And they activate the person. Once the person is at the top level, they activate the person to produce other outcomes. And I don't want to go into details, but one of those people were given to me as a security person. And then when we're investigating a matter, his name appears in the web, and discovered that they activated that young man once he was in a job that's strategic. So you can't work like it was an innocent operation, easy. It wasn't. It was tough.
Yes, thank you. Thank you. Thank you, Mr. Bani.
Thank you, Commissioner. Reverend, we accept that at the time you didn't do research, but you did ask about the timing, so let me just give you a quick sense of the timing of these cases. Eugene de Kock was in 1996. These were then when he was convicted. Freddie Barnard was convicted in 1998. The trial of Wouter Besson concluded in 2002. Eugene Terreblanche was in 2003. To be fair, the PEPCO 3 case, that only started in February of 2004, so that was a very recent one. But now, as you sit here today, you can see the kind of cases that he pursued and the convictions that he secured. Would you agree with me, knowing what you know today, that the accusations that you have made against Ackerman, that he would prosecute to fail, that he couldn't be trusted, that there really wasn't a basis to hold that for you?
Yeah. You see, I did not come here to critique Ackerman. I don't need to. I mean, he's old already. I don't need to. But give me the right to think the way I was thinking. I mean, if you talk about Basson, for instance, I was the center in that case. But my critique is that they were focusing on something that has nothing to do with my interest. And therefore, Basson gets acquitted. And so you can't say, I must not think like that. And I told them, because they came to talk to me about that case, he's the key person who produced the chemicals that were used against me. But that matter never saw the light of the day. He got acquitted. We're still taking care of him now, you know, in terms of where he is. And the other person you talked about who got released now was in Flak Plus.
Eugene de Kock?
Yeah. Ask where he is now. what happened. And so you can't say charged, therefore honest. I work on the basis of what is the interest. He just made headlines now in, I think, Mail and Guardian. He came out of jail and got taken care of. We dealt with Basson, and when he got acquitted and was found traveling, the US said to us, you can't let this man travel. And if you go to the history, Mandela was forced to take him back into the force. So it's not innocent things that were happening. We need to understand the context, the international networks, the interests. I don't want to go into detail because I'll soon be charged for having said things about individuals here.
Yes, we certainly don't want that to happen. Now, we accept that these were views that you held at that time, and that, as you say, you hadn't done research. You might not have been aware of the history.
But my experience with him.
Yes,
I don't need research about him.
Yes, Reverend, we'll come to your experience shortly. I just want to wrap up on this view that is expressed. And as I said, we accept that this was a view held back in 2004, that you were suspicious that Ackerman and perhaps others were going to use your case to precipitate a crisis so that they can go and arrest some of the ANC leadership. May I ask, is that a view that you still hold on to today?
Yeah, but that's going back to that history. I had a view like that, and they are no more relevant now. I mean, Ackerman, it's not relevant now. And actually, most of that generation, police, security police and others, were 2-3 years older than us. Most of them are gone, who planned what needed to come out of it. So I wouldn't want to confuse where we are now and then. And I want to hold my view that I had no reason not to suspect, and I have no reason to change my view about it.
Okay, so you had no reason to change your view, and as Commissioner Khama put it to you, this is the view that you held when you testified in May of this year.
Yeah.
Thank you. Let's return to your statement, and let's jump to paragraph 32, which is on page 11.
Page 11, yeah.
So there are a few questions arising from this paragraph, and just to refresh our memories, I'll read it. In respect of the prosecution of perpetrators, in my case, those who had poisoned me, some feared that the enthusiasm and urgency with which certain members of the prosecuting authority wanted to arrest and charge the 3 police officers who had been identified as being involved was part of the strategy to precipitate action against some of the leaders of the new government, especially the 37 whose application for amnesty was turned down. Such a result could be achieved in the name of equality, namely by balancing people to be charged between the perpetrators of gross violations of human rights on the one side of the apartheid regime and ANC leaders who were involved in or who commanded the war resistance against the apartheid regime on the other. Now you've already been referred to the media statement of the 14th of May 2004, which then NDPP and GUKA released, and I believe that's on page 84. And in that media statement, NDPP and Guka states that the NPA has decided not to prosecute those matters and have closed, I beg your pardon, it's 85, and has closed its file in respect of that case. But notwithstanding that statement and the closing of the file, as I understand your evidence, and indeed there's other evidence as well, that concern persisted for some years thereafter. You would agree?
Yeah, by the way, because this was brought to my attention, I had to think about it. But the fact that a file is closed does not mean it can be opened. It can be opened. If you say, I've got new evidence, you can open the file. So even if the National Prosecution Authority would have said that you can be charged later if you can show there was evidence. That's why I argued that withdrawing the case against Mr. Zuma at that time, he was not the president. I said to comrades, if a prosecutor withdraws a case, it does not mean it can't come back. So that you've closed a file doesn't mean it can be opened unless I don't understand the legal processes.
Well, actually, Reverend Chikani, you wouldn't make a bad lawyer because you're not wrong.
Yeah.
If new evidence arose, there'd be nothing stopping the NPA from re-looking at the matter
Yeah.
and starting a prosecution. So you're completely correct on that score. So would I be correct in saying that this concern, the time period in which it was being raised, ran from around 2003 all the way into around 2007?
Yeah, I would say it was there from the time of the TRC. I don't remember the times, but it was there from the beginning, immediately, because the ANC went to the TRC based on the original design of the TRC, where you go as the leader and accept everything that people did who were under command and say, I'm applying for amnesty, which covers everybody. But the law was not structured that way. And so they hit the wall. So they remained without amnesty, the key leaders. So in a sense, that worry was there that these people have not been given amnesty, so they are vulnerable to being charged. That was the view, and I still hold that view, that there was a risk of, if anybody wanted to destabilize you, would just have to arrest somebody. And you can see it happening at Madlanga when a thing like this happens. And then you've got war again. So that's my view.
Thank you. If I can take you back to the first line of that paragraph, where you state, in respect of the prosecution of perpetrators, in my case, those who had poisoned me, some feared that the enthusiasm and urgency with which certain members of the prosecuting authority wanted to arrest and charge the 3 police officers, then you talk about it precipitating, that then would precipitate action against the leaders of the new government, especially the 37. Would I be right in saying that the certain members of the prosecuting authority, that would have been Advocate Ackerman and his colleagues in the Priority Crimes Litigation Unit?
No, I didn't know the people, by the way, in that prosecuting authority at all. I met Ackerman as well because he had to deal with me. And so in a divided system, remember that even the old order was divided about the agreement, settlement, political settlement. So that some would explode bombs as others were signing agreements. So I wouldn't know where it would have come from, but it could happen.
And did those who held that view, did they regard the enthusiasm and urgency with which the NPA were pursuing those cases as a problem?
When I've explained my case, my position is I was worried about them rushing without having the evidence. That was my worry. So I can't speak for all the others who spoke about this matter, but you need to convince me that you've got the evidence and that you can find a successful prosecution. If you can't, I can't support you to prosecute people when there's no evidence. Not that they are not guilty, but you don't have the evidence. So the speed with which it was done, at that moment, it was like waves within the system that, there's this attempt. And so people had a good reason to worry. But I was in the center, so fortunately I was in touch with them, with Ackerman at least, or Advocate Piccoli.
And would you agree that the concern around the enthusiasm and urgency in relation to, for example, pursuing your case, that concern was misplaced because Ackerman and his colleagues were simply doing their jobs?
No. That's why I said go ahead.
Yes.
I didn't stop them. I said you must decide. I never said I slowed down. I didn't. But I was concerned that they mustn't do it to lose. I never said I slowed down. I didn't. But I was concerned that they mustn't do it to lose the case. I think I've repeated myself now about this matter. A prosecutor can take a matter to court with the intention of losing the case.
Yes.
If there's conspiracy in the system. So that's all I was guarding against. So it was not misplaced, no. I was suspicious and wanted to make sure that when it happens, I've got the info. It is after they agreed on plea bargaining and whatever they did, and the information that we got, that I felt comfortable, not about the document, but the direction they were going.
Yes. Well, just to wrap up that topic, I suppose that one does get corrupt prosecutors. I suppose that happens in many countries.
Yeah.
But we have put it to you, and perhaps I should put it to you pertinently, that we will be submitting to the Commission that there wasn't the slightest basis to make that accusation against Ackerman, that he would prosecute in that fashion without evidence, or for purposes of failing, or for purposes of precipitating cases against other people. Any response to that?
No, you have the right to make your determination, but it doesn't change my view. Yeah, my view remains that that's what I believed, and nothing in my interaction with Ackerman could have made me to think otherwise.
And the commission will decide.
Yeah, the commission will decide. But I hold my view.
Of course, and you're entitled to your view. Yes.
Yeah.
Let's move on to the next paragraph. You mentioned there was in fact a heated debate between some NPA officials and the command of the police about this matter, as there was an indication that some within the NPA were planning to arrange for the arrest of the ANC 37 leaders. Can I ask you, do you recall who in the command of the police was involved in this heated debate?
It depends on the particular moment, but I mean, you'll find at some moment Commissioner Jackie Silibi was commanding the police, and Advocate Pilo Piccolo was responsible for the NPA. And from the documents I've read, I don't want to claim, I don't want to own the information because it's not my original information, but there were differences in approach.
Yes, and can we ask, did you have any discussions yourself with Commissioner Selebi in relation to the TRC cases?
No, because I mean I discussed with him many.
Reverend, can I ask you
I
just
discussed many things with Selebi, but I avoided making my problem their problem. I felt they must deal with the issues. They are state entities, and they must deal with the issues. Where I was required, like in the case where there was a debate about issues about source files, with the national prosecution wanting source files in intelligence, and the police saying, no, you can't have them. The president would then task me to get involved and engage and mediate. And I don't need to go to details because it's not relevant here. I'm making an example where I am tasked. But if there are debates amongst them and they have to resolve the issues, it's up to them because they've got their responsibility in terms of the departments.
Thank you. That's noted. In the same paragraph, but on the next page, 12 at the top, you point out that one of the ANC 37 was President Thabo Mbeki himself. Were you aware that Commissioner Jackie Selebi was also one of the ANC 37?
No, I don't remember. I don't remember the list. No.
And then moving on to the next paragraph, 34. It pretty much says the same thing as the previous paragraphs. Some believe that those wanting to have the 37 leaders arrested wanted to create a crisis that would force the ANC leadership to back off from post-TRC cases. That fell under the category of unfinished business of the TRC. And then you say others wanted to prosecute people for the sake of it without considering the implications, and then you make reference to the circumstances of our transition from an unjust racist system to a just and democratic system. There were, at the time, many conspiracy theories going around. I'm not sure that we understand the implications of prosecuting people for the sake of it. The crimes in question were all serious crimes like murder and kidnapping. And normally speaking, for very serious crimes of that nature and magnitude, prosecutions do follow if there is the available evidence. And I know you had a concern about the available evidence, and we've already had that exchange. We don't believe you had a basis to impugn the prosecutors. But assuming that there was the evidence, what would be the implications of going ahead with those prosecutions?
I'm trying to look for a way, because it's the same question, same issues that you are dealing with there. The way I would answer it is that at one moment I had to think about if somebody tried, because if you tried, whether you'll succeed, it's another question. If I woke up and found that Mbeki is arrested, it would destabilize the country, because you're not yet at evidence, you are not yet in court. It's an arrest. And once that happens, it can create enormous difficulties if it happened. And I was worried for a moment during that time that if anybody tried it, it would be a huge crisis in the country. So it's not at the level of evidence and except that comes later in the politics you have to manage. It's what happens when it happens now.
Yes, I can certainly see that a prosecution of the president could be destabilizing. But what about a prosecution of a former general or a security branch officer? That wouldn't necessarily be destabilizing?
No, the thinking at that stage was, if you arrested one of them, they will go and do the other. Remember that police force was the old police force. It was. So they could do anything crazy. And I'm saying me now. That's me saying it. And so arresting people to destabilize, I don't want to talk about Madlanga now, but you can destabilize the country by acting in a way that's meant to create the crisis. So, yeah, the political complexity of the moment was difficult. I've said here that I worked with VIP protection people who tortured me and so could qualify to be arrested because they've committed a crime. But we decided to have a settlement where you don't do that. So so the moment, I think I want to repeat again, we're not running a normal government. We're managing the difficult transition, and anything could happen in that regard. I mean, even the arrest of the ANC leadership just before the negotiations, you'll remember that. It created a huge scare, and there had to be negotiations to neutralize that. You know, the Maharaj, what did they call it? Maharaj?
Sorry to interrupt, Reverend Chakani, but if we can get back to the issues before this commission, as interesting and serious as these other examples are, may I put it to you that the implications that are being referred to here is that where the one side, as in the former generals of the apartheid regime, if they were prosecuted, the argument goes that it would then precipitate prosecutions against the ANC, which then could be destabilizing.
Or vice versa.
Or vice versa. Although, in terms of the destabilizing effect, would you agree that it would only be prosecutions of senior officials like the president that could potentially be destabilizing?
Yeah, I mean, the position of a person matters in a situation like this.
Thank you. Let's move on. And if I can ask you to turn to page 14. We're going to pause at paragraph 40. So in this paragraph, you make reference to
Which paragraph?
Sorry, Chairperson, paragraph 40.
40.
Yeah, on page
Thank you.
14. I'm just going to paraphrase, Reverend. This is one of the paragraphs where you set out your efforts to get to the bottom of your attempted murder. And you make the point that you wrote letters to President F.W. de Klerk, Adrian Vlok, Johan van der Merwe, and several others. And this was all prior to the Truth and Reconciliation Commission. But all of them denied knowledge about your poisoning. Am I correct in saying that Vlok and van der Merwe at that time also denied knowledge?
Yeah, I'm not sure it's after, during or before the Truth Commission. We'll have to check the dates. It could be in that process, but yes, it did. I wrote to all of them, and none of them said, I know about this. None. They had many words and whatever, the way they explained it. In particular, I was interested in Surgeon General Knobel, who was the Surgeon General. He was responsible. Basson worked under him. So that area of the chemical weapons was controlled under his jurisdiction, and he denied it. But Basson, I got involved when I got to the presidency. I had to draw the policy processes of how you manage that, turn it into a defensive chemical facility rather than offensive, to be within the law. And there's no way Surgeon General Knobel would not have known. So they really said, no, all of them. I also wrote to what is the...
Yes, it's okay. You don't have to go into all the detail.
Yeah.
We know that you made extensive efforts to get to the truth.
Yeah.
But am I right in saying that this was through the course of the 1990s, even if you can't remember the specific period?
Yeah, I don't remember the period. But there are dates in those letters, so it could be checked. Yeah.
So, given your efforts to reach out to these individuals, including Vlok and van der Merwe, and given the fact that they did have the opportunity to come clean at the TRC, shouldn't the law have just followed its normal course, and that no further accommodation should be given to them, since they had their chances to come forward and chose not to?
Yeah, no. And Vlok admits that he did not tell the whole truth at the Truth Commission. Yeah, because what he gave me after, this was before they responded to my case. So they missed the opportunity at the Truth Commission. When I asked them, they also denied. So, but that's the information I wanted to extract from them, which I got later.
And then if we can jump a few paragraphs to the next page, that would be page 15 of paragraph 45. And here you detail even further efforts to persuade individuals to come forward. Sorry, it's actually page 16.
Yeah, page Paragraph 45.
Yes, and here you explain that in May 2003, through the media, you wrote an open letter to fellow South Africans, basically inviting them to come forward, tell the truth, and give information. And at the bottom of that paragraph, you write, in addition, I made public my offer to waive my rights to sue for damages or seek prosecution to make it easier for perpetrators who had failed to take advantage of the TRC process to acknowledge culpability or involvement in apartheid-inspired attacks on me. In light of that last line where you say you would waive your right to seek a prosecution, do you accept that while you may do that, in actual fact, the sole decision as to whether to prosecute or not rests with the NPA?
Oh yeah, no, I agree. It means I wouldn't initiate it myself, but I got to understand that for me to use that information, you need people to put it on record in a court, because otherwise I wouldn't use the information, wouldn't be able to use the information. No, I accept that. And I've also said nobody should do what I did. I'm not expecting other people to do that. It was me.
And then let's move along to paragraph 47. That's on page 17. Here you state as follows: however, as more and more evidence was coming to the fore, preparations were being made to arrest the 3 police operatives. It was the imminence of the arrest in the latter part of 2004 that sparked a flurry of activity. And let's pause there. The flurry of activity, would I be right in saying that this ultimately resulted in those arrests being suspended when then Justice Minister Mabandla directed acting NDPP Silas Ramaita to suspend prosecutions of TRC cases until the guidelines had been formulated? Is that your recollection?
No, I wasn't involved at that level. I'm talking about the flurry of activity around my case and the debates and followed by interaction with Ackerman and others after that, I think, because the case was in August 2007, yeah.
But did you subsequently get to hear of the intervention by Minister Mabandla to suspend those cases pending the guidelines to deal specifically with them?
No, I mean, yeah, if you hear or read about it here, doesn't mean I was aware at that time. So I can't confirm. I can't confirm because it's not my original knowledge.
Thank you. If we can just return to the role played by Jan Wagener. And here I want to refer you to the transcript of an interview that he did with a journalist by the name of Hofstadter. And that transcript is at page 109. It's too long to go through in detail. But essentially, he tells this journalist, Stefan Hofstadter, that at the time when these arrests were going to take place, he contacted someone, without mentioning a name, who took the planned arrest to the presidency before the arrests were halted. Now, do you have any recollection of someone approaching the presidency at this time in relation to those arrests?
No, I don't remember anything like that, yeah.
No,
You'll recall that I said I separated my personal matter from the presidency so that I don't muddy the waters. Yeah.
Yes, but perhaps if I can just refer you to your paragraph 67 on page 23.
Page.
So it'll be page 23.
Yeah.
And here you're referring to your case. So you say, throughout these processes, I interacted with the NDPP from time to time. I also sent the letter to the Minister of Justice to raise my concerns at the end of the case. And the last line, I also kept the President informed about what I was doing without involving him in the matter. So it seems that you were keeping the President informed about your case.
Yeah, I had to keep that distance, but if I'm going to go to court tomorrow, I would then have to make the President aware so he's not surprised. But I avoided getting him involved in this matter because it affected me. And it was at a personal level. It was not an issue the office was dealing with. But because I work in the presidency, I could not just be absent without letting him know. So I made him aware this is what I am doing. But he didn't have to do anything about it himself. And he did not. It's a principled person about keeping the Chinese wall in between, those types of things.
Thank you. Now, you've indicated that at the time you were not aware that Minister Mabandla had directed the then acting NDPP to suspend the TRC cases pending the development of guidelines for the cases. But now that you do know, do you have a reaction to that intervention? Or any comment to offer?
Can you repeat the question?
Yes. You mentioned that you were not aware that the Justice Minister at the time directed the then acting NDPP to suspend the TRC cases pending the guidelines. But now that you do know that happened, do you have a reaction or a comment on that intervention?
If I may, my apologies. Mr. Ramaite gave evidence on this issue, and the words he used were not suspend. To take us directly to the word suspend that was used.
Yes. For what it is worth, Mr. Vani, what is the point of Reverend Chikane's opinion in the circumstances?
Well, I think we'd be interested in his opinion on that intervention, because that intervention comes from a political level.
Yes.
And it's his evidence that...
But it's ex post facto.
It is ex post facto.
Yes.
Chairperson, to save time, I'll move on.
Yes, thank you.
Let's move on to paragraph 48.
You're going back from 67.
Yes, I did a fast forward, Chairperson, at least Commissioner Koma, but I'm now coming back.
Okay.
48.
So it's page 17, where we were previously. But we're moving on to paragraph 48. And this is the paragraph that you've mentioned previously, where you say your position was simple and deeply personal. Just disclose to me the story, then use the channel the President announced. And then just jumping a little, their concern, however, was that there was no legal provision or framework for what the President had announced, and that it left the perpetrators vulnerable. There was no guarantee the arrangements with the NPA would not result in the imprisonment. Besides, the plea bargain agreement had to go to court, but this exposed them to the risk that a court could make a different ruling that could also result in imprisonment. So the question I have is, this is what happens in the normal course of our criminal justice process, and these are the normal risks. Why should there be special guarantees for these offenders and not others?
Well, that's what I said to them. There's no guarantee that can be given. If you do plea bargain agreements, a judge can make a different determination, and you can't have a guarantee. So, and they thought I can give them a guarantee or influence government to give them a guarantee. I said I don't. And I think that's why that angle was abandoned.
Thank you. Let's turn the page to paragraph 49. And this is, you then explained they preferred their original position, which they had presented to the NPA and the political leadership, particularly de Klerk and Mbeki, namely a general amnesty. I just wanted to ask you, were you aware that the generals had also made proposals, although they had asked for a general amnesty, they had also made proposals that were not that dissimilar to the guidelines, in which immunity could be offered in exchange for a measure of disclosure. And these are recorded in the meetings that the two authors, Bebenza and Schmidt, wrote about. I'm not going to go into the detail, but just for the record, Chair, that's on pages 74 and 71 of the bundle. Were you aware that they had also made a proposal that stopped short of a general amnesty?
I wouldn't know the details, okay. But this is, they were doing everything possible to get amnesty without any giving anything. That was their attitude. They just want general amnesty. And it failed at all levels. I don't remember us reaching a stage where we said general amnesty is the solution. No. And they knew about it. And that's why I also pushed them back to say, I can't help you. With that, you'll have to go through the process.
And if we could turn to your paragraph 50 on the same page, and this is where you talk about their concern about implicating others, their own colleagues and comrades. They were worried about exposing or giving evidence against one of their own. Would you accept that at all times they never wanted to disclose information that could lead to prosecutions of their colleagues, or perhaps persons high up the chain of command, maybe even in the State Security Council?
No, there was no doubt about the fact that that's what they wanted all the time. That's why I pushed them hard to say it can't work like that. You will have to give the information, and at the end, they gave more information at the end, because when you look at the plea bargaining, my concern is there were people who could have been charged following that plea bargaining arrangement when you read it, and then nothing happened. And that's my complaint. So in a sense, they wanted a way, but they gave more, including admitting that their instruction to kill me and others came from a higher level. They didn't mention P.W. Botha by name. But when you read the text, there was no doubt it was. So, yeah, they tried their best, but couldn't succeed until they got out of the woodworks. That's what I'm talking about. And because it was clear their foot soldiers were going to be charged.
So the one name that has cropped up in the evidence was the person who replaced Johan van der Merwe, and that was Basi Smit.
Yeah.
Were you able to follow up post the plea bargain as to what was taking place in relation to him and potentially others?
Yeah, I think that's where I end up saying I've done my best, I can't go further. Because it's in the text, everybody sees it, and nobody did anything about it. And there's a limit to which you can fight on your own. I think I was satisfied I've got the information about my poisoning and the command line, and I can't fight further. Even Basson should have been charged, but he wasn't. Now I learned there's a stray dom who didn't execute this order, and Smith came and executed it. I don't understand why he wasn't charged. The information is there.
And to complicate matters at that time, individuals in the NPA who might have had an interest to pursue further cases, such as Advocate Pekoli, who was then NDPP, and Ackerman, who was then head of the PCLU, we know that not long after the plea bargain, Advocate Pekoli was placed on suspension, and thereafter Advocate Ackerman was removed from his duties in relation to the TRC cases. Were you aware of that?
Yeah, no, I mean, I would have got info about all the other processes, some I know directly. But what I am saying is, I can't fight this battle alone.
Yeah, but were you aware that Advocate Pekoli left and Mr.
I know.
Ackerman was removed?
Yeah, I don't know much about Ackerman,
Yes.
but I know about Pekoli. The
Yes.
Pekoli matter, I know very well because I was there. He was senior enough for us to know that. But the circumstances of his leaving, it's a different matter.
Thank you. Just moving on to paragraph 51. And I'm just going to paraphrase that. This is the paragraph in which you point out that Vlok and van der Merwe didn't abandon their foot soldiers, and they came forward and moved away from their strategic lies. So, on behalf of the families, we will be putting it to the Commission that that those two actually acted in self-interest, because if they hadn't come forward, then they would have been prosecuted next. Do you have a comment on that?
No, I mean, it's clear that they came out of the woodworks precisely because their foot soldiers were going to be charged. So it was a push-pull to get to where we ended up in this case. And yeah, there could be self-interest. I mean, people calculate what is best for them, and they decided to join the three who were going to be charged. They actually volunteered to join them.
And if we can turn over the page to paragraph 52, that's on page
Same.
19.
Yeah.
And here you refer to your discussions with Vlok and van der Merwe, and you say that their lawyer Jan Wagener was also involved. Did you meet with Jan Wagener?
No. He was involved. I know from them because remember I went through the advocate Pretorius to Wagener. So when you deal with them, the name of Wagener comes up.
Then if we can move on to deal with matters arising from the charges against the accused. And just to save time, I'm actually going to skip that page. We can turn to the next page from paragraph 60, page 21.
Before you get there, I want to ask whether you do have a break.
Yes. Would you like a comfort break, Reverend?
It would help.
Yes. I think we'll take, how much time do you, 10 minutes will be sufficient?
Yeah, it should be fine.
Yes. We'll take a 10-minute adjournment. How long do you still have to go, Mr. Vani, if I may inquire?
Yes, Chairperson. I would say approximately 20 minutes.
Thank you. We'll take a 10-minute adjournment.
2006. Also in your evidence in chief, that's at page 54, line 3, you spoke about the same incident and you described it as Flock going through a Damascus experience. So we want to put it to you that it was not a true Damascus experience for Flock, because if it had been, then he wouldn't have just come clean on your case. He would have come clean on all other cases, and in particular, for example, he was on the hit list and what happened to those individuals. Would you agree?
Yeah, that issue about Flock and the Damascus experience, I've had to deal with many times. I don't think I'm able to determine what happens in somebody's heart. I think and Damascus experience also doesn't express itself in the same way. I know that he had a Damascus experience in 1994, and it's personal. I can't go into the details. And that's why he came to me. So if he says that to me, I can't measure him about all the sins he has committed, because I don't know. He responded to me in that particular manner, and I accept that. It's me. It's not, nobody should respond to it like I've done. But I know the personal circumstances, but he's no more here, so I can't do much about it.
All right, let's move on to paragraph 62, which deals with your meeting with Advocate Ackerman and also Advocate Marga. And we don't have to go into all the detail because it has been explored with you previously. This is the meeting, of course, where he threatened you with a section 205. And I just want to put it to you that I want to put what Advocate Marga said about that meeting, and it's a handwritten comment on the letter that you wrote to Mrs. Bridget Mabandla, MP, the Minister of Justice, that 22 October 2007 letter. You attached it to your statement. It originally comes from an attachment to the statement of Acting NDPP Mshere. It starts from page 39 of the bundle, and if I can refer you to page 40. And next to the paragraph where you describe the meeting, Advocate Marga writes, not true, I was present, no threats made in my presence. Do you have a response to Advocate Marga's handwritten comment?
Yeah, I have already responded to this matter earlier. I saw this comment. I was surprised that it was brought in the form of a comment like that. But I'm shocked, actually. I mean, and I don't want to talk about him because I don't know him. I only saw him in that room. You couldn't have a dramatic issue about being threatened with 205, and he misses it. And he said nothing in that meeting, actually. He accompanied him. I can see there's a debate about whether he was an assistant or not. That's irrelevant, but I'm really shocked because it happened in my office and there were two of them. And in my statement, you'll realize I say, he would be my witness. I didn't know he's going to come here and deny it. So I don't know the man, so I can't rely on. But for him to say it's not true when he was there, and the most significant issue, it's about that letter he wanted me to sign, and after that things turned around, and I've said, he himself in one of this, in his statements, describes who Ackerman is and his character behavior. And I've said that I'm sure he's used to that behavior, so for him it didn't shock him. I was shocked, and he can't miss the fact that I said, try it, you can do it.
So just on that score, and I think Mugger used the words robust or something along those lines, and as you said, your response is, well, he's used to Ackerman behaving like that. And what I want to put to you is that the TRC itself called for a robust prosecution policy to deal with the cases that were not amnestied. Now, as I understand it, you've accepted that it was Ackerman's job to prosecute, and he was adopting a robust approach. Can that really be held against him, that he was pursuing the case with that kind of vigor?
No, I don't accept being treated like that. I come from an apartheid society where I've been treated badly. And I don't like a person like Ackerman to sit in my office, and when I refuse to sign the document, he then threatens me. I can't accept that. That's not prosecution. It's not being robust. It's being offensive. And threatening a person is not an easy thing. So that's why I'm worried about acceptance of this behavior by his partner who came with him, the team.
As I understand it, the issue was around information that was in your possession in relation to the case. Did you ever hand over that information to the NPA?
No, they didn't ask. If they were saying to me, you've made progress, can we have the information so that we can strengthen our case? That's one thing. But to say, you shouldn't be talking to those people, you are interfering with the prosecution process, and then threaten me. I've gone through this before, so I don't know, and I know you're going to say I'm deviating. But I've been in a hit list, and somebody confessed, gave us the information, where they were trained, etc. And the police arrived to demand that I hand over that information. So it wasn't the first experience I've had. So he behaved like those police who were not concerned about me being in a hit list, but concerned about getting the information from me.
Just a reminder to address yourself to the chairperson.
No, I'm saying I don't accept that. There's no way of explaining that behavior. It's not for me.
Let's turn to that unsigned letter that you declined to sign. That's at page 159 of the bundle. You have been referred to it earlier. So the letter, just to remind ourselves, the letter which you didn't draft, it was drafted for you, and you were asked to sign it. It was addressed to the NDPP, and essentially it says, at the conclusion of my meeting with Advocate Anton Ackerman, I deem it imperative to convey that the independence and discretion of the NPA in deciding whether or not to prosecute in any given matter should not be impeded. And then in the next paragraph of substance, should your office exercise a discretion in favour of a prosecution against the above perpetrators, I would not have any objection thereto. Would I be correct in saying that you don't necessarily dispute those two assertions?
No, because in my statements, I do say they can prosecute, do their job. But you don't come to my office with a predetermined letter without warning and say, sign the letter. I don't work like that. Should have said, would like to bring a letter to you to do the following, explain this. But don't put it at the end of the difficult discussion and you say sign. And my view is the prosecutor can do all these things as long as if I said, exercise your responsibility and do it. But to then stop and read this letter and say, now I will sign it. I mean, I have not asked to be helped to do a letter, you know. But if it's predetermined, I become suspicious. Why do you come with a letter for me to sign?
In your evidence in chief, you mentioned that such a letter could be used in the could be used by the NPA in its conflict or battle with the police, the SAPs. How could they advance their position in that conflict?
No, produce a letter I've signed which is not written by me. You know, for him to, what is he going to use it for? Didn't explain to me. You give me a predetermined letter. I don't sign letters like that. I apply my mind to what I sign, and in that environment, I'm saying, it wasn't the environment where you would, take the letter, read it on the spot, and determine whether you want to sign it. I think that's really the point I'm making. You can't have a hostile environment and come with a predetermined letter. I had even forgotten its content because at that point I didn't look at the detail. Because if you wanted me to sign, I would say, leave it with me, I'll look at it and you'll collect it tomorrow. But I can't sign a predetermined letter.
It is titled proposed letter. I wonder when it did not become proposed now. It's a proposed letter you see there.
Yeah. But I wouldn't have signed a proposed letter. I mean, it would have to be put properly in a letterhead or something and become the final after we have agreed.
Yes, Reverend, when you had a meeting with Advocate Ackerman, was this letter read out to you?
I don't even remember it being read out. I really don't remember because I'm saying that meeting was not a lovely meeting, actually.
Yes.
Yeah, so as I'm saying, if you told me the procedure to say, this is how we're going to do it, this, and in that process you need to sign a letter like this, and could have said, can I leave it with you, you can change, you can do whatever, but this is the reason why we have to do it. But that's why even this early morning, when I read it, I was a bit surprised to say, did I send such a letter? Of course, the proposed at the top tells you it wasn't processed. Yeah.
Giovanni, before you move on from this letter, I have a question. Reverend Chikane, if you read paragraph 1 of that letter, it's asking you to agree or to convey that the independence and discretion of the National Prosecuting Authority in deciding whether or not to prosecute in any given matter should not be impeded. In any given matter, so more than your case. And then the second paragraph says, this view pertains to the above matter too. So, as I read this letter, you are asked to sign to convey the view that the NPA should be left alone in their duties to decide whether or not to prosecute in any given matter.
Yeah.
And so what was being asked of you was more than just consultation over your case. Would that be correct?
No, that's correct, because it also says above matters too.
Yeah.
Maybe I can also thanks for that, but I need to just restate my state of mind at that time. That I had said, and I say it in my statements, they are the prosecutors, they must do it the way they normally do. I've not impeded anything. So I didn't think that I need to write to the national prosecutor and the National Prosecuting Authority to say I will not impede or there's no impediment. No, but I've told you that you can go ahead. Yeah, why should I sign a letter like this?
Okay.
Besides my suspicion that it's predetermined.
Thank you very much.
Mr. Vani?
Thank you, Chairperson. While we run the... Actually, let's move on from the letter, if I may. The question of consultations that did not take place between yourself and the NPA in relation to Section 105A, Sub 1, Sub B, Sub Roman numeral 3 of the Criminal Procedure Act. And of course, that deals with plea bargains or plea and sentence agreements. And in that particular section, which has already been read out to you, there is a requirement to afford the complainant an opportunity to make representations to the prosecutor, although it does say where it is reasonable to do so. Now, it was put to you by my learned friend that there was no interaction between yourself and the NPA on this topic between the meeting that was held with yourself and advocates Ackerman and Maga on the 19th of January 2007, and then the subsequent plea and sentence agreement that took place later. You did point out, though, that Advocate Pakoli had actually called you to discuss the matter. So I just want to put to you two paragraphs from the affidavit of Advocate Pakoli before the Ginwala Commission. I'm going to start at page 144, at paragraph 294. And I'll just read an extract. Again, this is Pakoli speaking. Reverend Chikani had in fact been extensively consulted in relation to the proposed prosecution. I personally held a number of discussions with him during the course of the many meetings we held over an extended period. These were one-on-one meetings of which no particular record was kept. I did, however, discuss the decision to prosecute with him on several occasions. Would you agree with Advocate Pakoli on that score?
No, I wouldn't want to depend. Wouldn't want to debate the frequency of meetings. I did say that Advocate Pikoli intervened and engaged with me about the matter. The only thing I'm saying is about the content of the plea bargaining. But he did, over the telephone, I remember, tell me that they've proposed 10 years suspended for 5 years, this and the other. But it wasn't the final document, yeah. So I can't say, because we worked in the same environment, so I can't say we didn't talk many times. But I can't remember the details, yeah.
And if I can draw attention to one more paragraph, and Reverend, this one was in fact on the page that was missing from the original bundle that we have distributed subsequently, and we just numbered it 146A. And if I can just refer you to paragraph 301. And you'll see from the paragraph above that it's in relation to the negotiation of a comprehensive plea bargain and sentencing agreement. And then 301 reads, when this development occurred, I discussed this with Reverend Chikani on or about 30 May 2007. This was at the time that I was invited to attend a meeting of the National Security Council in regard to the Browse report issue. I informed Reverend Chikani both of the decision to join Mrs. Flock and Van der Merwe as accused in the prosecution and of the general nature of the plea bargain and sentencing agreement, which was being discussed with them at the time. Do you have a recollection of that?
Yeah, I can't deny it because I convened the National Security Council, so we could have met there, but I mean I can't remember that. That's why I'm saying Advocate Pikoli worked in the same environment with the DGs, structures, and National Security Council, and so would have met many times, I would imagine. So I can't say it didn't happen. No.
Thank you. And either in that encounter, or perhaps when he called you, did you offer any objection to the proposed plea bargain?
No, the only thing, the plea bargain content he talked to me about, it was headlines of what they are working on. But I don't remember having that document with me to express a view about it. Maybe I'm not supposed to do that in terms of their sense of consultations. But because it was done in Afrikaans, I wouldn't have forgotten that I got the document, because I would have said, hey, translate this to make it easy for me, because it was a dense document. Yeah, but he talked to me about the content, but it's not the same as reading and another, because that document makes me look like I'm a violent person. You know, I mobilize UDF and all that. Just go and read it. You'll see that it's written in a language that makes me a person who destabilized the state. Except that these guys tried to kill me. So it's the wording. I would never have missed it.
If we can return to the letter that you addressed to Minister Bridget Mabandla, that's set out in your paragraph 64.
Page 22.
Page 22. Now, I don't wish to traverse the letter. You've explored it previously already. But of course, the bottom line is that you were very critical of the conduct of the NPA in this matter and how they handled your case. And yet, you expressed a different view, and perhaps let me just start with an issue that I don't think has been dealt with previously. You complained in your statement that it was left to you to explain the outcome of the case to the public as a victim. But isn't it true that you in fact held a press conference in your capacity as Director General in the Presidency on 17 August 2007 at the Union Buildings? And in this regard, I refer to page 194 of the bundle. It's a press release from the South African Government Media Office titled Chikani to address media on Flock court case, 17 August. And I'll also refer you to the next page, 195, which reports, it's an IOL press article, which reports on that press conference. So can you explain, your complaint is that government left it to you to talk to the public about the outcome of the case, even though you were a victim?
Yeah. I think I've explained it before.
Just raise your voice, Reverend.
Yeah, no, I'm saying I've explained it before. Nobody accompanied me on this journey. Nobody. And I went to that court alone, except the communications officer in the presidency who said, but you can't go alone. I said, but it's not presidency business, this. So you can't come along with me. And he said, no, I'm coming in my personal capacity with you. And so I was on and throughout. And then when I came in, there were two protest groups, one supporting the accused and the other one supporting me or protesting against. And I left there. I did say in my evidence that when I left there, I had deep depression. And I went to the office, couldn't work, and decided I'm going home. So I called my dear wife and said, I'm on my way, coming home. And so the media then screams, wants to talk to me. And so I arranged to talk to the Margaret. I would have expected when you have a case like this, which was seminal, is that good English, and the first of its kind, that they would have, everybody would have said, this is a way in which we could solve most of the problems. But nobody did. So I don't want to blame anybody. I mean, it's choices. You're not required to do so. In that court, the media filled the place. The family members couldn't come in there, or friends who wanted to come with me. So I'm not complaining about government. I'm just saying I had to do this all by my own. And so those press reports, yes, it's true.
Thank you for that clarification. I want to contrast your letter that you wrote to Minister Mabandla with the opinion piece that you published in the City Press
Yeah.
on the 18th of August 2007. Commissioners, that's on page 196 of the bundle. It's dated 18th of August 2007 and is titled NPA Role in Flock Matter Offers a Lesson for Our Country. And we don't have time to go through the whole article, but in that piece you describe the outcome of the case as a win-win, and that it gives practical expression to the spirit of the 2005 NPA guidelines and shows the proven capacity to handle sensitive and complicated political matters in an unbiased manner. So, Reverend, I have to ask you, how do you square the sentiments expressed in the City Press opinion piece with the severe criticism you leveled against the NPA in your letter to Minister Mabandla?
I started when I talked about being asked to give evidence and participating in these processes, because you end up with that headline, page 198. Chikani contradicts himself. Enquiry, yes. Now, I don't need this. So you get it because you do something. If you do nothing, nobody will have headlines like that about you. And I've explained this. I was dealing with government in a confidential letter to say the things I must say to them. As a Director General in the presidency, I can't say that in public. And here in the City Press, I did an article to explain this event for the public, and I didn't think I must go and complain to the public about what happened internally, and I presented it as a pointer to what government could do. And it's a success story in a sense, because indeed I got what I wanted to get from them. So it's a success story. I can't go and publicly publish gripes about who did this. I can't even go and say anything about Ackerman. I leave those things inside and deal with the public differently. So there's no contradiction here. It's an approach to the public and an internal matter that the minister should know about. And I thought I would get that response to say, yeah, let's fix these things, because it's for purposes of fixing it. The response did come, but late. And I'm not aware that nobody said to me, yeah, we are doing the following to fix it. I didn't get it. So there's no contradiction. That's how I operate. I will not go and publish things in my house, in the public. I fix them in the house. But when I deal with the public, I deal with the public.
Thank you for your explanation. We would submit that there is a contradiction, although you've explained it, that you were unable to be frank with the public for the reasons that you have put up. And so I think I'm correct in saying that when looking at those issues, your real views are set out in the letter to Mrs. Mabandla and not the public opinion in the piece in the City Press.
Yeah, but then we must agree with Dreyfus. The Mabandla letter has nothing to do with the public. I wasn't going to do that and will not do it even today. The issue is that there was something faulty within government, and I've acted in a way that will help to fix it. But I'm not going to report to the public about the internal matters. So, I mean, you may reach your own conclusions. My view is there's no contradiction here. It's deliberate. It was calculated. It's not a mistake. It's knowing what you make public and what you fix internally. Otherwise, you will be announcing problems in cabinet every day, and it can't work like that.
Thank you, Reverend. My final question, it deals with your evidence that the fear or concern of people in government that the NPA might still be coming after senior leadership, as in the ANC 37. And you've explained why that fear persisted. We don't have to revisit that. But I want to put it into you that narrative, that was particularly pushed by the former generals themselves, by people like Jan Wagner and others, with the specific purpose of preying on the fears of people in government in order to get them to clamp down on prosecutions more generally. Would you agree with that contention?
Yeah, I don't like the approach. This is not what we were dealing with. Indeed, the generals wanted that outcome. They deliberately planned it. But it doesn't mean that we must ignore it, because it's planned, it's meant to produce a particular outcome. It will be irresponsible if you are government to ignore that plan by the generals. And so we had to deal with it. But I must say, because it's the last question, to say that actually it would be good to take some of you to go and put you at that moment to deal with the issues we're dealing with, and you wouldn't come back the way all of us think about, because this is theory. We're running government, and when you run government and there are risks, you manage those risks. I chaired the National Security Council of officials, and the President chaired the cabinet. I received all the intelligence information. And you don't see it and go public and go and tell the public, hey, there's a story here. It's a completely different environment. So I won't say they didn't mean to cause the new leadership to behave in a particular way. Of course, they intended to do that. But it doesn't mean you must ignore it. You need to deal with it. And and also prevent such a thing happening. And I can't make other examples because this is a commission. But we had to stop a coup elsewhere. You get the information, you then plan how you're going to stop that coup. But you can't get the information and say it's a threat, and leave it. So I think you have the right to make your conclusions, but that's how, in that operational moment, I understood and dealt with the matters.
Reverend, I want to thank you for your patience in assisting us with our questions and our probing. We are grateful. No further questions, Chairperson.
Thank you. Mr. Soni, any re-examination?
Listen, regrettably, there is one issue I must return to.
Yes.
Reverend, the document at page 159, that's the proposed letter, has been referred to several times.
Yeah.
Can I start off by asking you to turn to the index of the documents in the Kalata Group bundle to cross-examine you. I think that's...
Yeah, at the beginning.
Yes. So if you look at item 16 on page 3, and you'll see on the right-hand side it refers to page 159. Will you read
Page
into...
3, are you talking
Sorry,
about
page
the
3.
index?
Yes, page
Yeah.
3 of that.
Yeah,
So if you look at 16, which is the second item on that page, item 16,
yeah.
could you read into the record what that document is described as?
An unsigned proposed letter prepared by the NPA from the Reverend to NDPP Piccoli, dated 19th January 2007.
Oh, okay. So we know what the letter is. It is a letter that was prepared by the NDPP,
Yeah,
and it was proposed that that is the letter that you would send to the NDPP.
yes,
Okay, let's go to the letter itself now. You'll see that
Yes.
that letter is dated the 19th of January 2007.
yes,
And then you'll see it's addressed to Dear Vusi.
yeah, I wouldn't address him like that.
But we know that the Vusi, or we must assume that the Vusi referred to here is
Piccoli.
Advocate Piccoli.
Yeah,
Right. Now, the next thing I want you to look at is the title of the letter. It says State versus Smith, Otto, and van Staden.
yes,
Now you'll see that 2 names are missing from there.
yes.
And which names are those?
It's Flock and Van der Merwe.
Okay, can I now then ask you to look at page 146. And you'll see at page 299, sorry, page 146, paragraph 299.
99, yeah.
There's a reference to the fact that the decision was to proceed against the 3 individuals against whom a prosecutable case had been established.
Yeah,
All right. And can I ask you to look at paragraph 300? It says, during the course of the next few months, the legal representative of Messrs. Otto, Smith and van Staden, who was also the representatives of Flock and van der Merwe, held detailed negotiations with Advocate Ackerman and members of the PCLU in regard to a plea bargain and sentencing agreement. And then he says these developments were reported to Advocate Ackerman, by Ackerman to me.
yes,
Now the point I want, and then if you look at paragraph 301 on page 146A, that's the page that has been added. It says, when the development occurred, I discussed this with Reverend Chikane on about the 30th of May 2007. This was at the time that I was invited to attend a meeting of the National Security Council in regard to the Browse report issue.
browse
I-
more. It
So it
should be
should be
browse
browse
more.
more.
Yes, I'm just reading what it says here.
Yeah,
It says, I informed Reverend Chikane both of the decision to join Flock and Messrs. Flock and van der Merwe as accused in the prosecution, and of the general nature of the plea bargain and the sentencing agreement which was being discussed with them at the time.
yes,
Now, would I be correct to say that on the 19th of January 2007, the plan was to prosecute only
three.
the 3 foot soldiers.
Yes.
And the plan to include Mr. Flock and Mr. van der Merwe came after that, seemingly around May 2007.
That's it.
Now, I want to go back to a point you made earlier, that one of the matters that you were concerned with in relation to Advocate Ackerman. Well, before I do that, can I ask you, the addition of Mr. Flock and Mr. van der Merwe, as I understand it, is information that you had secured from them. That's Mr. Flock and van der Merwe.
Yeah. Now I can see the way it happened between January and May. I was interacting with them.
Yes.
And then when they couldn't solve the problem, to avoid their foot soldiers being charged, then they said, we're going to join our foot soldiers to be charged with them. That's why it comes later in the game. It has to do with them now feeling we can't solve the problem, so we're going to include ourselves into this process.
And those were interactions between you and Mr. Flock and Mr. van der Merwe.
Including van der Merwe. They came together in my office to discuss.
So they came to see you?
Yeah.
Okay. And then they were added as accused persons in the matter of Smith, Otto, and van Staden.
That's it.
Now, you might remember one of the issues that was raised with you was your suspicions, I think that's the word you used, about Advocate Ackerman.
Yes.
Now, if this prosecution that was contemplated in January 2007 had taken place without the information you gathered from Mr. Flock and Mr. van der Merwe, would I be correct in saying that the likelihood is that they would not have been accused persons or prosecuted?
I'm not sure I can actually say authoritatively. What I know is that in my interactions with them, because it was a number of times, it wasn't one meeting, in my interactions with them, it gravitated in them having exhausted all the other alternatives, deciding they're going to be charged together with the foot soldiers. So my engagement with them would have partly contributed. I don't want to say it was my sole engagement with them, but they were not prepared to let the foot soldiers go and be charged alone. And that's why I say I appreciated that, because other leaders would leave them to burn without feeling any guilt.
And the expression you used is they came out of the woodwork.
Yeah, that's why they came out of the woodworks, because they realized they couldn't stop the charges against their foot soldiers. And they were, I mean, it was an instruction. I must say that commissioners, that reading this file, I got more information about the pardon and the application information. It was a difficult instruction, instruction that says go and kill this reverend. It's not an easy one. They are also human in a sense, except those who lost their consciences. But that stray dom I read during the break decided he couldn't do it. If you went to that paragraph and moved, and Smith came and carried it out. So we arrived there because of my engagement with them. But I can't say that they may not have arrived. Yeah.
Those are my questions in re-examination.
Thank you, Mr. Soni. Reverend Chikane, we know how traumatic it has been to come and give evidence before this commission. To this extent, we are profoundly grateful to you for having come to give evidence and to assist the commission to be able to discharge its mandate properly. You are now excused as a witness.
Thank you.
Chairperson, from the position of the evidence leaders, may we also join you in expressing our appreciation to Reverend Chikane. It's not been an easy process for him.
Yes.
And we regret the trauma he's been asked to go through by coming.
Yes, thank you. What is the date next week on? 16. Next week, Monday, 16. Where's your phone? Mr. Siminya?
Chairperson, the matter is to stand until Monday next week.
Yes. What is the date on Monday?
1/7, I'm told.
1/7.
Yes.
Yes. These proceedings are then adjourned until the 17th of August, 2026 at 10 o'clock.